Ladies and gentlemen, Your Excellencies, ladies and gentlemen, dear friends, it is a special honor for the EFTA Court that Koen Lennartz, President of the Court of Justice, has so generously accepted to give the keynote speech. As his schedule is very tight this morning due to the visit of His Holiness the Pope to Luxembourg, I will be brief. Before giving the word to him, I would like to go down memory lane and mention a highly important, albeit somewhat neglected judgment of the Court of First Instance, Opel Austria versus Council. In short, the case turned on whether a Council regulation imposing tariffs was compatible with the Article 10 of the EEA Agreement. The Council, supported by the Commission, maintained that it was and claimed that Article 10 EEA could not be interpreted in the same manner as the corresponding article of the EC Treaty, as the EEA did not aim for the establishment of a single market without internal borders. This was robustly rejected by the Court of First Instance, holding that the EEA Agreement involved a high degree of integration, with objectives which exceeded those of a mere free trade agreement. The Court also examined in detail the various features of the EEA installed to ensure homogeneity interpretation. This judgment is, in my mind, the first signal from the community courts that the EEA was indeed what the contracting parties had set out to achieve, an extension to the internal market to the EEA states. As such, a discerning audience might suspect the reason for me to bring up the Opel Austria case is indeed that the President of the Chamber delivered this judgment was none other than Koen Lennartz. The life of EEA would have been pretty short with a reverse conclusion. President Lennartz, the floor is yours.
Thank you, President Herrensson, and thank you especially for having recalled this Opel Austria case, which indeed bears testimony to the fact that the Union legal order considers the European Economic Area Agreement as a very special agreement. It is not just an association agreement in the formal sense of union law, but it is an agreement which extends the scope of the internal market to 3 more states. And that is what the Opel Austria case bears out. As you know, the Council decision was annulled in that case, and there was no appeal, so the judgment became definitive. It's one of the very important judgments of what is today the General Court, the Court of First Instance, as it was called at the time, where with 3 judges we really placed the cursor, so to speak, on our understanding of what the EEA is all about. Now, together with my co-author, which will give, for the reasons already explained, and I apologize for that, the bulk of our more technical explanation about homogeneity in the European Economic Area, and especially homogeneity in the development of EEA law and EU law, which is a shared responsibility for the EFTA Court and the Court of Justice of the European Union, I would myself, first of all, express congratulations to the EFTA Court. And that is well in place, these congratulations. It was not obvious to make over 30 years a successful court which was only covering the countries which are parties in the European Economic Area without being EU members, and to have as the express purpose under the agreement to contribute by way of developing case law, a homogeneous legal space, rechtsraum, a legal space for the EU and the non-EU member states of that broader area. I think we can say, after 30 years, and after the Court of Justice of the European Communities, as it then was called, had struck down a proper EEA court for reasons of cohesion of the EU legal order as such, we all know the history, it was then decided to have two parallel courts, but which would read one another's jurisprudence, take it properly into account, and come to, as far as possible, common outcomes. Yesterday, we had, and the day before yesterday, we had during 2 days an official visit of the Supreme Court of the United States with the Chief Justice and a number of justices. And we discussed how comparative law may contribute to the making of jurisprudence in our court. And we said, yeah, that's an obligation, not an obligation, that is a sort of an attitude to take into account case law stemming from other origins. And they looked at us and said, yes, but taking into account, what does that mean? That's not a hard and fast rule. I said, well, this is very widespread. In German law, for instance, Rücksichtnahme, you take Rücksicht auf, you take into account. That is that you take cognizance of it, and when you do so, you're a different mind, simply because you have knowledge of what you have read, of what you have seen, and what you contribute yourself to develop accordingly. It's not an obligation. You're not formally bound, but you take into account. So that is what I said there. Here, of course, it goes much further. It's a taking into account with an obligation of outcome, homogeneity. Une obligation de résultat, as they say in the French civil law. And I think our courts are both working in that spirit. We read the other case law, and as much as can be done in cohesion with the proper law, and for us it's then union law, we take into account and we try to be coherent with the EFTA case law. And as you know, there have been cases where our court quotes the EFTA court. Not so many, because of course the subjects covered in our jurisprudence very often fall outside the scope of the EEA agreement, but when the subjects do fall, it is mentioned just like we mentioned the European Court of Human Rights steadily whenever fundamental rights are concerned. I think that led, and Stanislas Adam, here present, my star referendaire, and we wrote a study in the celebratory book for the 30 years of the EFTA court, going into more details of this whole development, and also how the Court of Justice looks at the EFTA court from its perspective. And he will also, in his further explanations after I have to go to the Pope, he will then explain that in more technical details, not too technical because this is a celebratory event, but nevertheless. And that study, in fact, strengthens me in the conviction that the EEA globally is a success story precisely because our courts produce, maybe not in all single cases, but in 95% plus of these cases, homogeneous outcomes which really make that the internal market is extended to 3 more states and actually indirectly over a whole range of bilateral agreements also to Switzerland. And I say this because this factual extension of the internal market has also led to the extension of the Schengen zone, which is enormously important. Without the success of the homogeneity in terms of jurisprudence as far as the internal market subjects are gone, there would not have been the trust. Now it comes, the mutual trust between all these states to abolish controls at the internal frontiers. From my perspective, just as important as the EEA agreement on itself is the fact that these states belong to the Schengen zone. And that also applies to Switzerland, a non-EEA state, but which over a network of bilateral agreements is also part of this common venture. Once you say an area without internal frontiers, you inevitably have to be somehow bound by the common values. No, Article 2 is formally not applicable to the EEA as a whole. I said formally. Substantively, it is. When we have our case law on the rule of law relating to some member states of the European Union, we have EEA states, non-EU member states, participating in our proceedings. First and foremost, Norway. And that is totally understandable, because you can't be in an internal market, in a Schengen area, without internal frontiers, without trusting one another's judicial systems. And of course, as a knock-on effect of all of that, you can't have open borders without judicial cooperation. In civil matters, Lugano. In criminal matters, the European arrest warrant. Oh, it's called differently, eh? European arrest warrant, but it's exactly the same. That is what we had in the Icelandic, Croatian case, Ruska Federacija, where the court indeed spoke about a common European identity. It's a very strong case. It's April, I think, 2020, Grand Chamber case of our judgment. It's worth reading because it indicates the common European identity based on these same values. And we said, yes, the relationship with the EFTA states is so intense that this type of far-reaching agreement, because a European arrest warrant, or let's say an interstate arrest warrant, inevitably rests on the trust that the judges of one state have in the judges of another state. It is an Icelandic judge issuing a European arrest warrant, which, well, European between quotation marks, under that bilateral agreement, which has to be implemented in a European Union state. So this presupposes a far-reaching mutual trust that all these national judiciaries are operating under the principles of the rule of law, declined in the requirements of independence, impartiality, fair trial rules, justice within reasonable time, because justice delayed is justice denied, etc., etc. To me, those are extremely important developments. At the heart, even though it is not within the scope of jurisdiction of the EFTA court, because it falls formally outside the EEA agreement, it is nevertheless the EFTA court which is to be credited as a reliable partner in the European Economic Area, with the fact that this mutual trust is indeed growing. And it's the basis for this further integration, which is the proper feature of the common area. Now, after Brexit, that's my last perspective for this morning. After Brexit, there has been concluded with the United Kingdom, first the withdrawal agreement, but then far more importantly, the Trade and Cooperation Agreement. It's again formally outside the EEA, just like the whole network of bilateral agreements with Switzerland. However, it is taking over the agreement with Norway, with Iceland, EU-Norway, EU-Iceland, when it comes to judicial cooperation in criminal matters. The court delivered its first Grand Chamber judgment in a case which we pseudonymized as Alcaster, a request from a British court for the surrender of a person caught in Ireland, person who presumably or allegedly had participated in a terrorist act in Northern Ireland. And here again, the court had to explain that, of course, there is sort of degrees in formalized mutual trust. The mutual trust is an entire part of the structure between the member states of the European Union. That goes back to case law, maybe epitomized best in the opinion 2/13, where we say that member states should trust one another, that they are complying with fundamental rights as equals, and that the member state should not look deeply into the other member state is complying or not, because it is presumed to comply as a member state of the Union. And then we go on and we say, well, with Norway and Iceland, where we have also these bilateral treaties on the surrender of people sought for criminal offenses, there is also a particular high degree of mutual trust, because that holds together with the European Economic Area Agreement and with a broader network of agreements which are based on the shared values of Article 2. That is the European identity of which we spoke in Ruska Federatia. And then you have the United Kingdom, a previous member state, and still a party to the European Convention on Human Rights. And that will normally do, but of course on the side of the European Union member state, when the European Union member state implements such a surrender request, it is implementing union law, because that is based on the bilateral agreement with the UK, which is concluded by the European Union as such, and therefore that is an act of union law. And when member states are implementing that act, they must of course comply with the Charter. So there you see, it is another construction, but the inspiration is largely also drawn from what we have done in the EEA. So I conclude, and to pass over to Stanislas Adam, I think that the European Economic Area Agreement is an important contribution to the broader Europe, whereby the acquis communautaire, they said at the time, now we say acquis de l'Union, the Union acquis, can flourish beyond the formal borders of the European Union to other European states sharing the same fundamentals as far as living in a democratic society based on the rule of law and respectful of human rights is concerned, and that this opens the way to further forms of integration which are only possible when the core essence, the internal market integration, the Schengen zone integration, is guarded by courts which read their jurisprudence reciprocally, which respect one another, which take into account, but the strongest form of taking into account, with an obligation of outcome, that is to produce judicial, legal homogeneity. That is what our two courts are committed to. You have proven over 30 years that you are extremely successful and loyal in this regard. We try to be the same. So congratulations with the 30 years. Many more years to come. The more convergence we have in Europe, also in the present geopolitical context, the better it is. I'm now passing over the floor to my star referendaire, as I said, and I'm going to the official visit of His Holiness Pope Francis. Thank you.
Thank you, dear boss. Thanks to the organizers of this conference, especially President Reinsen, Registrar Einarsson, and of course also Bryndis Palmarsdottir for the excellent contacts when preparing the book and the conference. This anniversary offers an occasion to get back to the very foundations of the EEA itself and its purpose. The original purpose was a result of the combined effect of a series of accessions and a wave of harmonizing measures in the second half of the 80s. Against that background, it was believed that economic and competitive fragmentation on the continent between the communities and the EFTA countries would be harmful for both parties. A deal was thus sealed. Free market access within the EEA would be guaranteed, thus integrating the economies of the participating states. But that access was, of course, made conditional on EFTA EEA states abiding by, essentially, virtually, the entire body of EC internal market rules. That normative level playing field, of course, made sense only if legal certainty was created for the undertakings and investors. And a key factor in this respect is, naturally, that the interpretation of those common rules is harmonious across the area, as the President has recalled. That harmonious interpretation and implementation of those rules was necessary not only to promote competition exclusively based on merits, but also to ensure, let's not forget, consumer protection, equal consumer protection across the continent. I'll come back in a minute into more detail on some essential aspects of the institutional and procedural aspects of that homogeneity requirement, which is a central feature of the EEA, as you all know. Let me just highlight first that this original purpose seems to me and to President Lennart to be even more obvious or pressing 30 years later. As the recent Draghi report illustrates and suggests, European industry and competitiveness have become more and more vulnerable in the global economy over the last decade. That is partly due to what can be safely described as environmental, social, and fiscal dumping by some of the EEA's trade partners. In the judgment Ruska Federacija, which President Lennart mentioned several times, the court recognizes the special relationship between the EU and the EFTA EEA states, a relationship characterized by proximity, long-standing common values, and European identity. We believe that the EEA, which is no less than the backbone of that special relationship and the basis of your jurisdiction, is a key asset to reinforce innovation and thus competitiveness in that more difficult context. That level playing field, as regards free movement and competition within the EEA, can only be achieved thanks to a system of independent courts. And therefore, the lessons which the Court of Justice drew in the recent past from EU primary law, connecting effectiveness of EU law to the rule of law value, seem to us to be plainly applicable within the context of the EEA. Of course, homogeneity is not an easy objective to achieve in the two-pillar structure which resulted from opinion, essentially opinion 191. That two-pillar structure means, in essence, that our two courts share the ultimate responsibility not only to uphold EEA law within the limits of their respective jurisdiction, but also to do so in accordance with the homogeneity objective without any of those courts being formally subordinated to the other. As we know, in the first EEA opinion, the court drew a distinction of nature and purpose between EEA, the EEA agreement on the one hand, and the EEC treaty on the other. Some of the findings there of the court, some of the principles laid down in this opinion would have long-lasting effect on the constitutional charter of the EU. We find formulas such as the treaties being a constitutional charter of the community based on the rule of law, or the idea of integration and thus limitation of member states' sovereign rights in ever wider fields. Given the systemic differences, those systemic differences between the two agreements, the court observed that the similar wording of EEA law, internal market law, replicated in EEA law, did not suffice to achieve the homogeneity objective. It had to be achieved by other means, notably a system of judicial adjudication that would ensure uniform application and interpretation of EU internal market rules and competition rules. And in this respect, indeed, the first draft EEA agreement posed serious threats to the EU legal order. Whilst seeking to achieve that objective, it posed significant threats. It meant that there was no guarantee that the Court of Justice would not be bound or limited by the EEA Court case law interpreting such rules. Judges of the Court of Justice would also be sitting in that EEA Court, which posed issues of judicial independence in subsequent cases before the CJEU on the same provisions. And last but not least, the EEA Court would rule on the concept of contracting party, thus indirectly ruling on the distribution of competences between the EU and its member states. The two-pillar structure which was established in the aftermath of that opinion resolved automatically the last two issues. But there remained that risk of, let's say, common bodies of the EEA within the EEA distorting or undermining the autonomy of EU law, especially in the light of the court's jurisdiction, the Court of Justice's jurisdiction to interpret and to ultimately say what the law is in the context of EU law. The court set off that threat in Opinion 192, interpreting a declaration, a procès-verbal agréé, attached to Article 105, and which in a nutshell meant that common EEA bodies should not compel the court to adjust or change its case law, despite the fact that that declaration was outside the treaty itself, the EEA agreement, and despite the fact that its binding character was unclear. That was a very flexible understanding on the part of the Court of Justice of its jurisdiction in an opinion case, because the court for the first time there accepted to go beyond the strict scope of the agreement, the text of the agreement itself, to examine the compatibility of the agreement with EU primary law. And even more importantly, the court initiated in that opinion conditional compatibility. That is, the court said, only if such a rule or such a principle expressed in the procès-verbal, only if it is binding, can the autonomy of EU law be indeed fully respected. That technique would be confirmed in later opinions of the court. One famous example is the CETA opinion, opinion 117, where the court interprets the draft CETA agreement, or the part of the draft agreement concerning the setting up of an ISDS mechanism, making it clear that the future CETA tribunals can only operate and act in compliance with autonomy if, and only if, they, in a nutshell, limit themselves to sanctioning arbitrary or discriminatory treatment of Canadian investors, not calling into question, in other words, through proportionality analysis, the very heart of the legislative sovereign choices that have been made at EU level in terms of protection of certain public interests, such as environmental protection or social protection. Be that as it may, homogeneity cannot be ensured by the black letter of the treaty alone. We all know that Protocol 48 perfectly transposed all those principles and make that rule in the procès verbal binding for the common EEA bodies. More is needed, however, mutual respect between our courts, and most importantly, common efforts to learn about the other courts' case law are essential to strike that balance between autonomy on the one hand and, of course, the objective of homogeneity within the EEA. And this anniversary, as President Lennart has insisted, is an occasion to celebrate the fact that our two courts have largely succeeded in avoiding major discrepancies over the 30 years of coexistence. The EFTA court, in particular, has consistently taken into account the relevant case law of the Court of Justice. The famous L'Oréal case is a perfect example in which the EFTA court changed its approach on exhaustion of a trademark, interpreting the first trademark directive, adjusting it to the silhouette judgment of the Court of Justice. In essence, the Court of Justice in that silhouette case explained that under that first trademark directive, exhaustion must be EEA-wide, no more than that. And whereas prior EFTA court case law had developed an approach based on international exhaustion. Spontaneous cross-fertilization nevertheless goes beyond the formal limits of the homogeneity requirement. Your court has clearly taken some inspiration in the Court of Justice's case law regarding access to documents or locus standi, and that must be welcome. The fact that the homogeneity requirement has no unlimited scope means, moreover, that not any discrepancy in the case law of the two courts on the terminological or hermeneutical categories applied by them is problematic from the point of view of homogeneity, precisely. The SCAN team case is a perfect example. The EFTA court explains why it deemed it necessary to depart from the court's most recent case law on the independence requirement to qualify as a national court, but openly explained why the specific place and importance of administrative appeals, appeals before administrative bodies in EFTA EEA states justifies such a distinction. President Lennart and I do not perceive there any significant issue for homogeneity insofar as such interpretations take into account the specific traits of EFTA EEA states without compromising the fundamental objective of creating a level playing field for economic operators and citizens also across the European Economic Area. On its part, the CJEU has also regularly referred to EFTA, the EFTA court case law to interpret or to substantiate its interpretations of EEA law. Let me now conclude and let me turn briefly to the future. Groundbreaking EU legislation with EEA relevance, as the standard formula says, has flourished in the recent past. I could mention the Corporate Sustainability Reporting Directive and, of course, the AI Act, Regulation 2024-1689, adopted in June of this year. Sooner or later, our two courts will be called upon to interpret those complex acts, which deal with contemporary issues affecting millions of citizens and undertakings across Europe. Those issues are better reconciling freedom of enterprise and growth with the need to protect our planet, and regulating artificial intelligence to preserve our fundamental rights and values, and even more importantly, our mode of living based on pluralism, tolerance and inclusion. I make no hazardous bet if I say that our two courts shall play a crucial role together with national courts in upholding such new norms in the future. We believe that we will be collectively, as EU Court of Justice, EFTA Court, better prepared to tackle those challenges if we reinforce our informal dialogue in the future on topics of common interests. That will be to the benefit of citizens' trust in European justice, for which we share responsibility. I thank you for your attention.
Your Excellencies, ladies and gentlemen, dear friends, here I am again, and let me repeat that it is a pleasure and an honor for me to welcome you on behalf of the EFTA Court to our anniversary conference celebrating 30 years of the EEA and the EFTA Court. Well, concerning the Pope, in some quarters the EFTA Court has erroneously been accused of being more Catholic than the Pope. So perhaps it's fitting that we have had a divine intervention in our schedule. Our keynote speaker had to cut short to meet with higher authority, His Holiness Pope Francis, who is visiting Luxembourg today. When you're up against such a competition, there is not much that EFTA Court can do. While I cannot promise any divine insights, I hope it is though not too bold of me to suggest that the rest of today's schedule will be heavenly. And before going any further, I would of course like to extend my warmest thanks to Stanislas Adam for stepping in the big shoes of his boss at such a short notice. I'm delighted to say that we have a record turnout with over 300 participants registered to celebrate with us on this special occasion. Among the esteemed participants at our conference are judges from the Court of Justice and the General Court, the European Court of Human Rights, and Supreme Courts of the EU states. I'm also pleased to note that we have 4 former judges of the EFTA Court here today: Karl Baudenbacher, Henry Bull, Þorgeir Örlygsson, and Per Christiansen. I think that when the EU agreement was signed more than 32 years ago in Oporto, few thought that it would surpass its infancy, let alone that it would be celebrating 30th birthday. But yet, here we are. We decided to maintain the court tradition of publishing a book, as we did for the 10th and 20th anniversary. The book is called The EFTA Court Development in the EEA over 3 decades. In my foreword of that book, I note that the preceding decade has been difficult with the outset of an unprecedented global pandemic and the Russian invasion of Ukraine. These events have demonstrated the importance of EEA membership for the EFTA states, and I note the story of Brexit may serve as a cautionary tale which highlights the importance of the internal market for economic and political stability. However, I do not intend to dwell on world affairs, but rather turn to the order of the day, which is very much inspired by our anniversary publication, and all the speakers are among the contributors, and many of them will be drawing on their contributions today. The first speaker on the agenda is Arnfinn Borgsen, Vice President of the Court of Human Rights, who will look at the EEA and the ECHR from Strasbourg perspective. In this context, I would like to underline that I find that the EFTA Court's development of its fundamental rights jurisprudence is one of its prouder moments, and I very much look forward to hear Arnfinn's thoughts on that from the perspective of his court. Following on from him is Thérèse Blanchette, Secretary General of Council of Europe of the Union. She will discuss whether the institutional setup of the EEA, the Court and the EFTA Service Authority, could be extended to cover also the agreements the EFTA states have with the EU in the field of justice and home affairs, a topic that is very close to my heart. Since we are here to celebrate an anniversary, I would also like to add that Thérèse was present at the creation of the EEA as a member of the EFTA legal team. After lunch, Hildiko Ellingsen, partner at Lund & Co. and associate professor at Oslo University, will discuss a topic of fundamental importance: effective judicial protection under the EEA agreement. We, of course, have seen very significant developments in that regard under the EU law and in the last decade, so the question is to what extent they are mirrored under the EEA law. Then it is the turn of Professors Halvard Hogeland Fredriksen and Gunnar Thor Petersson. Unlike the previous speakers, they will not be presenting their contributions to the anniversary publications, but something rather different, but very much in the spirit of our birthday celebration. They will present a list of the 10 cases of the EFTA Court they believe to be of the greatest significance. I must admit I'm very curious to hear which cases they will make it to the list. Following on from them, the court registrar, Ólafur Jóhannes Einarsson and Jonathan Tomkin, member of the Commission's legal service and a regular pleader in front of the court, will tell you more about the anniversary publication. We are very honored that the Norwegian State Secretary Maria Varteresian, responsible for the EEN and European affairs, is here with us today, and she will close the conference. Ladies and gentlemen, and thank you very much for your attention, and I wish you all a fruitful conference. I will now hand over to my colleague Michael Reiertsens, who will moderate the proceedings this morning.
Good morning to you all. In this first session before lunch, we will have two distinguished speakers, which the President has already announced. And the first one out is Arnfinn Bårdsen, sitting to my right here. And Arnfinn Bårdsen, he needs no presentation for the Norwegian lawyers who are present here today. He is in Norway a most famous and respected lawyer who is known for his work both as an associate professor of law at the University of Bergen, as a judge and acting chief president at the Gulating Court of Appeal, also in Bergen in Norway, and since 2008 as justice in the Norwegian Supreme Court, to which he was appointed as one of the youngest Supreme Court justices in all times, I believe, with only the age of 41. Yes, he nods, so that's good. And after 11 years in the Norwegian Supreme Court, Arnfinn was elected as judge in the European Court of Human Rights, where he has been president of section since 2022. And since July this year, he has been one of its vice presidents. Now, what the Norwegians may not know is that Arnfinn, he was also one of my supervisors when I wrote my PhD. And that was a much more difficult task, I would say, than the task he has in front of him today. So I'm quite certain that this will go well also. Now, Arnfinn, you have, throughout your career, you have demonstrated a broad interest in a number of legal fields, both through your work and through your many, I would say, extrajudicial writings. But I think it's fair to say that you have had a particular interest for international law and not least human rights law. And that is, of course, as we heard the President say in his opening, also reflected in the theme of your contribution and speech here today, which will center on the relationship between the EEA agreement and the European Convention on Human Rights, which you are going to present to us from a Strasbourg perspective. I will very soon give you the floor, Arnfinn. You can sit there if you want, or if you can step down. But before I do so, I will inform you that we will have about 10-15 minutes for discussion, reflection, and comments after Arnfinn's contribution. So please do not hesitate to indicate to me if you have anything you want to say, either during the Arnfinn's contribution or afterwards, and I will give you the floor as appropriate. And with that, I pass the word to you, Arnfinn.
Thank you indeed, Michael, for this very kind introduction. Presidents, distinguished judges, Your Excellencies, dear friends, colleagues, many predicted that the EEA agreement would never survive its childhood. They were wrong indeed, and I will argue in part because the treaty was actually quite cleverly construed, because it has proven extremely beneficial for all stakeholders, and because, and this connects to my topic, it has been handled with care and pragmatism. I greet today the EFTA Court with its 30 years anniversary, and I salute the Court for what it has achieved. I do this as a friend of this Court for so many years, and as a Norwegian Supreme Court on leave, Supreme Court Justice on leave, and I do it on behalf of your sister court in Strasbourg, the European Court of Human Rights. Let me start with some general observations on the EEA agreement and when viewed through the prism of the European Convention on Human Rights. And I recall here that EFTA and its organs are not high contracting parties to the Convention. They are therefore not as such bound under Article 1 of that Convention to secure the rights and freedoms set forth in it. Any complaint before the Strasbourg Court against the EFTA Surveillance Authority or the EFTA Court will inevitably be deemed to be incompatible ratione persona with the European Convention of Human Rights and therefore inadmissible under Article 35, paragraph 3. In this sense, the situation when it comes to the EFTA EEA institution is analog to that of the European Union, unless and until the EU exceeds the European Convention on Human Rights as envisaged by Article 6, paragraph 2 of the Treaty of the European Union. However, by the above, very little is said about the impact of the European Convention on Human Rights within EEA law, or about the EFTA Court's role in European fundamental rights protection, compared also to that of the Court of Justice of the European Union. On the contrary, these are complex and multi-layered issues. It needs to be emphasized at the very outset that according to the preamble of the EEA Agreement, the establishing of a European Economic Area will bring to the construction of a Europe based on peace, democracy, and human rights. Thus, even though the EEA Agreement evidently does not have a specific provision pertaining to the fundamental rights protection, the EEA Agreement assumes some sort of coherent linkage between the functioning of the agreement and fundamental rights protection at European level. Moreover, the ultimate goal of homogeneity between EEA law and EU law within the scope of the EEA Agreement can in practice only be achieved to the extent EEA law is interpreted and applied with due regard given to fundamental rights, in substance as protected by EU law. This will inevitably include the principle prescribed in Article 52 of the EU Charter of Fundamental Rights, i.e. that insofar as the Charter contains rights and freedoms which correspond to rights and freedoms guaranteed by the European Convention on Human Rights, the meaning and scope of those rights and freedoms shall be similar to those laid down by the European Convention of Human Rights. Consequently, in line with the proviso already mentioned that pragmatism is key to the maintenance of the EEA Agreement, the EFTA Court has emphasized in cases like Holship that fundamental rights forms part of the unwritten principles of EEA law, and that the provisions of the European Convention of Human Rights and the judgments from the European Court of Human Rights are important sources for determining the scope of these fundamental rights. Indeed, the EFTA Court has made reference to the case law of the European Court of Human Rights in a number of occasions, such as also the case of Posten Norge. And in general terms, the European Convention of Human Rights and the case law of our court is either perceived as representing, in fact, substantive limitations on EEA law, or more often as an interpretative aid. A recent example of this is the EFTA Court's advisory opinion in Norwegian Air Shuttle delivered 9 September 2024. Here, in upholding a strict interpretation of Directive 2003/87 on establishing a system for greenhouse gas emission allowance trading within the Union, the EFTA Court recalled, and then with reference to the judgment from our court in Strasbourg in the Klimaseniorinnen versus Switzerland, 9 April 2024, that combating climate change is an objective of fundamental importance given its adverse effects and the severity of its consequences, including its impact on fundamental rights. However, nevertheless, it's not fully settled or explored what systemic function fundamental rights have within EEA law, notably if compared with the role of fundamental rights within EU law on the basis of the EU Charter. And this, of course, also includes the role of the EFTA Court in what might be perceived as a trilateral setup of domestic constitutional rights in the EEA EFTA states, EU Charter-based fundamental rights, and human rights and freedoms as defined by the European Convention of Human Rights. When assessing the role of the EFTA Court in this context of fundamental rights protection, it must be taken into consideration that the EFTA Court is an international court sui generis in its creation, in its purpose, in its competence, and in its operation, mirroring the one-of-a-kind character also of the EEA Agreement itself. The characteristics of the EFTA Court viewed through this prism of Article 6 of the European Convention on the right to have access to a fair hearing before an independent and impartial tribunal established by law came before our court in Strasbourg for the first time in the case of Konkurrenten versus Norway. The case was decided by a chamber formation of 7 judges in what may be considered a landmark ruling regarding the European Court of Human Rights assessment of the EFTA Court. I add also, for the purpose of full disclosure, that I was a member of the composition that decided this case in Strasbourg. The company Konkurrenten had applied to the EFTA Court under Article 36, paragraph 2 of the SCA for the annulment of 2 decisions by the ESA, which had closed the investigation of alleged illegal state aid given by Norwegian authorities to a competing enterprise. Following a detailed examination concerning the applicant's position in respect of the 2 contested decisions and the legal interest required for the company to be granted legal standing, the EFTA Court concluded that the applicant did not have legal standing in respect of either decision, and accordingly, the EFTA Court dismissed Konkurrenten's application. In the complaint before the European Court of Human Rights, Konkurrenten alleged that Norway was responsible for a denial of access to a court. The applicant argued that Norway's responsibility under Article 1 of the European Convention was engaged because Norway was a party to the SCA and had thereby contributed to creating a system that, according again to Konkurrenten, the applicant, did not sufficiently protect fundamental rights. The applicant had no other ways to seek compensation, and the EFTA Court's dismissal of the applicant's case thus meant effectively that Norway was protected from any compensation claims. The Norwegian government submitted that the application targeted rather the EFTA Court and that the complaint therefore was incompatible ratione persona with the provisions of the European Convention on Human Rights. And moreover, the EA Agreement and the SCA offered protection of fundamental rights equivalent to that under the ECHR, and the complaint was, still according to the government, therefore manifestly ill-founded. And this view was supported by ESA. The Strasbourg Court, in its decision, confirmed its reasoning in cases such as Bosporus, that the high contracting parties would engage with responsibility under the European Convention of Human Rights should they transfer some of their powers to an international organization whose internal litigation mechanisms are manifestly deficient when compared with the requirements under the European Convention of Human Rights. As for the EFTA Court concretely, the Strasbourg Court emphasized that considering the fact that the EFTA Court was set up to operate as a judicial body similar to the European Court of Justice, and that the essential procedural principles governing the operation of the EFTA Court were inspired by those of that court, the only possible starting point could be that there were no such manifest deficiencies. This was, according to the Strasbourg Court, confirmed by specific provisions in the EA Agreement and the SCA, the EFTA Court's rules on procedure, and the EFTA Court's case law. When it then came to whether the applicant had rebutted what the Strasbourg Court called a strong presumption of lack of manifest deficiencies, the Strasbourg Court reiterated that in respect of Article 6, paragraph 1, the mere fact that an action is found inadmissible on the grounds of lack of legal standing does not mean denial of access to a court, provided that the applicant's submissions have been the subject of a genuine examination. In the proceedings at issue, the EFTA Court applied the relevant test for legal standing under the SCA. The applicant was fully involved in the EFTA Court's proceedings and had every opportunity to argue the admissibility of its application and to present the EFTA Court with evidence demonstrating that the application met the criteria for legal standing. Furthermore, the Strasbourg Court was also satisfied that the EFTA Court had given sufficiently detailed reasons as to why the applicant did not have legal standing in accordance with the applicable law. The complaint was ultimately therefore declared inadmissible as manifestly ill-founded by the Strasbourg Court. The Strasbourg Court's assessment of the EFTA Court and its procedural framework is obviously very important, notably since the Strasbourg Court, in reaching its conclusion, emphasized in particular that the EFTA Court is a judicial body deciding cases on a legal basis independently and impartially. Perhaps not a surprise, but important nevertheless to make clear the position of the EFTA Court in this respect, and that the EEA EFTA states can in principle not be held responsible under the European Convention on Human Rights for the decision taken by the EFTA Court. I now turn to the question of a possible state responsibility under the European Convention of Human Rights stemming from a member state's own implementation of EEA law in accordance with its obligation under the EEA agreement, i.e. the situation where the EEA law obliged a member state to do something which represent an interference with the right of freedom protected under the European Convention on Human Rights. Of course, the Bosporus presumption generally serves to determine in which instances our court in Strasbourg may, in the interest of international cooperation, reduce the intensity of its supervisory role as conferred on it by Article 19 of our Convention. And this Bosporus presumption was, as you know, introduced by the Grand Chamber of our court first time in a case called Bosporus versus Ireland, 2005, and was later confirmed by the Grand Chamber of our court in Avutins versus Latvia, 2016, which fell subsequent to the European Court of Justice's opinion 213 on the draft agreement providing for the accession of EU to the European Convention of Human Rights. The Strasbourg Court has summarized the key components of this presumption, its scope and application as established in its case law, as follows in 4 points. First, the states which are parties to the Convention remain responsible under the European Convention for the measures they take to comply with their international legal obligations, even when those obligations stem from their membership of an international organization to which they have transferred part of their sovereignty. Second, action taken in compliance with such international legal obligation is justified where the relevant organization protects fundamental rights as regards both the substantive guarantees offered and the mechanisms controlling their observance in a manner which can be considered at least equivalent, not identical, but comparable to that for which the European Convention on Human Rights provides. The presumption will then be that a state has not departed from the requirements under the European Convention on Human Rights when it does no more than implement legal obligations flowing from its membership of that organization. Third, a state will, notwithstanding the presumption just described, be fully responsible under the Convention for all acts falling outside its strict international legal obligations, notably where it has exercised or is empowered to exercise state discretion. Thus, the application of the Bosporus presumption is indeed subject to the condition that there existed no margin of discretion on the part of the domestic authorities. Fourth, the presumption of equivalent protection can be rebutted in the circumstances of a particular case if it is considered that the protection was manifestly deficient. In such cases, the interest of international cooperation would be outweighed by the Strasbourg Court's role as a constitutional instrument of European public order. Concerning the European Union, the Strasbourg Court has made clear that the substantive protection of fundamental rights afforded by EU law is equivalent to that of the European Convention, also taking into account the Charter of Fundamental Rights, including its Article 52, paragraph 3. The Strasbourg Court has also recognized that the mechanism provided by EU law for supervising observance of fundamental rights, insofar as its full potential has been deployed, also affords protection comparable to that for which the Strasbourg Court provides. The question is then, does this Bosporus presumption also apply for the EEA EFTA states when in the context of the EEA agreement? Again, the Strasbourg Court's decision in Concurrenten is key, being the first case before the Strasbourg Court addressing the issue. Here, the Strasbourg Court is clear that the Bosporus presumption does not generally apply within the context of EEA law, since the basis for the presumption established in Bosporus is in principle lacking when it comes to the implementation of EEA law at domestic level within the framework of the EEA agreement. The Strasbourg Court referred in this respect to the specificities of the governing treaties compared to those of the European Union, notably that there is within the framework of the EEA agreement itself no direct effect and no supremacy. The argument of the Strasbourg Court here is that the EEA EFTA state will in principle never find itself in the dilemma that the Bosporus presumption aims at solving, since the EEA agreement allows the domestic courts to refrain from applying EEA law if this is necessary in order to avoid the violation of fundamental rights as prescribed in the domestic constitution and or international human rights treaties, such as the European Convention of Human Rights. According to EEA law, the domestic courts retain their role as the guarantors of fundamental rights and freedoms, even when it comes to the implementation of EEA law. This position is illustrated by the plenary judgment of the Norwegian Supreme Court in the case of Holship, emphasizing the primacy of constitutional rights before EEA rights. Here, the plenary of the Supreme Court said, under and pursuant to Article 101, first paragraph of the Constitution, everyone has the right to form, join, and leave associations, including trade unions and political parties. If the boycott against Holship notified by NTF is protected by Article 101, first paragraph of the Constitution, any rights derived from the EEA agreement must yield. Similarly, the EFTA Court made clear in its Karim judgment 2020 that the EFTA states, in particular their courts, must not only interpret their national law in a manner consistent with EEA law, but are also under an obligation to ensure that their interpretation and application of acts incorporated into the EEA agreement does not result in a conflict with fundamental rights. The applicability of the Bosporus presumption was subsequently addressed and discussed in the Holship case before the Strasbourg Court. And again, for the purposes of full disclosure, I should mention that I was in the composition in this case, not in the Strasbourg Court, but as a member of the Supreme Court plenary composition, deciding the case at domestic level. So evidently, I had to recuse myself when the case then ultimately was decided by the Strasbourg Court. Just a brief on the background, the Norwegian Transport Workers' Union decided to organize a boycott of all shipping in Drammen involving the company Holship Norge AS. The union succeeded in obtaining a declaratory judgment of the lawfulness of the boycott from the Drammen City Court, and the judgment was upheld by the Borgarting High Court. Holship appealed to the Supreme Court of Norway, which made a request for an advisory opinion from the EFTA Court. On the case returning from the EFTA Court in a split decision, the Supreme Court of Norway ruled in Holship in 2016 that the boycott was unlawful since it was not sufficiently justified and did not satisfy the requirement to strike a fair balance between freedom of establishment under EUA law and the possible fundamental right to boycott. Relying on Article 11 of the Convention of Human Rights on the freedom of assembly and association, the applicant union lodged a complaint before the Strasbourg Court against the decision to declare their notified boycott unlawful. The Strasbourg Court found that the boycott had sought to protect, at least in part, the occupational interests of union members in a manner that fell within the scope of Article 11, and that provision was accordingly applicable. In addition, it was not contested that there had been a restriction on the trade union's rights owing to the declaratory judgment finding it unlawful. The question was whether the restriction flowing from that judgment had been necessary in a democratic society as required under Article 11, paragraph 2 of the Convention. In short, the Strasbourg Court concluded that it was, with reference to the extensive reasoning given by the Norwegian Supreme Court. My point here is rather than the Bosporus presumption and what the Strasbourg Court said about that. The Strasbourg Court recalled that in Konkurrenten, it had considered relevant that the EEA agreement does not include the EU Charter of Fundamental Rights or any reference to other legal instruments having the same effect. Now, in Holship, the court downplayed this element by saying As regards in particular the latter feature, the Court observes, however, as clearly stated by the EFTA Court in the Holship case, that fundamental rights form part of the unwritten principles of EEA law. Since this reflects the position which previously pertained under EU law, prior to successive EU treaty amendments, according to which fundamental rights were first recognized as general principles of EU law, the Court considers that the fact that the EEA agreement does not include the EU Charter is not determinative of the question whether the Bosporus presumption could apply when it comes to the implementation of EEA law or certain parts thereof. The Strasbourg Court's assessment of the nature and level of substantive protection of fundamental rights in EEA law had nevertheless no bearing as to the non-applicability of the Bosporus presumption in this case. On the contrary, the Strasbourg Court confirmed that the lack of direct effect and primacy of EEA law is indicative for the applicability of the Bosporus presumption as emphasized in Concurrent. I will finally, and rather brief, revisit the classic problem pertaining to the nature of the proportionality assessment in the balancing of conflicting rights and freedoms under the Strasbourg Convention and under the EU EEA law. Again, according to the plenary judgment of the Supreme Court of Norway in the Holship case, any conflict between a right to boycott, protected under Article 11 of this Convention, on the one side, and the freedom of establishment as prescribed in Article 31 EEA on the other, should be solved by a plain balancing of competing rights and freedoms. Accordingly, the Norwegian Supreme Court assessed the rights and freedoms under the European Convention of Human Rights and the freedoms stemming from the EEA agreement as being on an equal footing, the task of the Supreme Court being to harmonize the two by striking a balance between competing but commensurable rights. The Strasbourg Court had a different view on the normative structure in play. Indeed, it accepted that protecting the rights of others granted to them by the EEA law, such as freedom of establishment, may justify restrictions on rights under Article 11. However, the Strasbourg Court stressed that even when implementing their obligations under EU or EEA law, the contracting parties should ensure that restrictions imposed on Article 11 rights do not affect the essential elements of trade union freedom, without which that freedom would become devoid of substance. The Court then went on with the following important statement. The Strasbourg Court: there is a risk that the domestic court may balance the right under the Convention against the right under the EEA agreement in a manner that would generally only be appropriate had the issue before it been a matter of conflicting fundamental rights under the Convention. From the perspective of Article 11 of the Convention, EEA freedom of establishment is not a counterbalancing fundamental right to freedom of association, but rather one element, albeit an important one, to be taken into consideration in the assessment of proportionality under Article 11, paragraph 2. The risk just referred to is one which, while ensuring full compliance with their obligations under EEA and EU law, domestic courts must seek to avoid. Easier said than done, one might argue, but still, this is the position of the Strasbourg Court. In accordance with this ruling, from the perspective of the Convention, it is not a question of balancing competing rights and freedoms placed on an equal footing, but to assess whether and to what extent freedoms under the EEA agreement can justify an interference with fundamental rights, in this case under Article 11, paragraph 2. That provision requiring that the interference must be justified as being necessary in a democratic society. This may, of course, be seen as a corrective to the Supreme Court's approach, or at least as a good advice for future cases. There is possibly, some would say, a hint also to the EFTA Court and other stakeholders when it comes to how the Strasbourg Court sees the proper interplay between, on the one hand, fundamental freedoms under European Community law, such as the rights of establishment, and on the other hand, fundamental rights and freedoms as protected under the Convention. By way of summing up, if I might make, Michael, just 4 short points. First, the EFTA states are in principle not accountable under the European Convention on Human Rights for the ruling of the EFTA Court, the court being an independent court of law. Second, the EEA EFTA states bear full responsibility under the European Convention of Human Rights for their own implementation of EEA law, the Bosporus presumption not being applicable in this context. Third, and by consequence, it falls to the domestic courts in the EEA EFTA states to secure the respect of fundamental rights and freedoms also in the implementation of the state's obligations under that agreement. Fourth and final, as demonstrated by the findings of the European Court of Human Rights in Holship, even if the Bosporus presumption does not apply, the margin of appreciation does. Indeed, when concluding that there had not been a violation of Article 11 in that case, the Strasbourg Court emphasized that the Norwegian Supreme Court had remained within its wide margin of appreciation and advanced relevant and sufficient grounds to justify its final conclusion in the particular circumstances of this case. Important to note also the fact that an impunging measure was taken in order for the EFTA EEA state to comply with its obligation under EEA law may inform the scope of that margin of appreciation. To the extent this is the case, the conclusion that the Bosporus presumption does not apply might arguably lose some of its importance, if not in theory, so at least in practical and pragmatic terms. I closed my intervention by reiterating the greetings to the EFTA Court, and I do so in recalling the crucial role and the shared responsibility of the European courts in Luxembourg and Strasbourg, alongside with the European apex courts, in safeguarding a common European legal order, a legal order founded on the effective and coherent protection of fundamental rights and freedoms and of the rule of law. Thank you.
Now, the floor will soon be open for reflection, comments, and maybe questions which you might have. But I see that we have some time, some spare time. So that is why I will allow myself to make two reflections before I open up to you. And please think about good comments and reflections, because this is a contribution which there is a lot to react to. You may not want to react to my reflection, Arnfinn, but maybe some other in the audience will. And I have two reflections, and they both concern the fact that the Bosporus presumption does not seemingly not apply for the EFTA court in the EEA system, and that raises several questions. And first of all, it raises a question, of course, for the European Court of Justice and others, because what will happen then is that you might get an EU act into Strasbourg through the back door, through the EEA system, in which the Bosporus presumption does not apply. So in this scenario, the Strasbourg Court will fully review the EU Act through the back door of the EEA and the EFTA system, and that, of course, raises several questions on the relationship between both the EFTA Court, the European Court of Justice, and the court in Strasbourg, and our domestic apex courts. And it's a reflection. I'm not going to say anything more than that, but maybe someone else. Want to. The second thing I wanted to say is question whether the justification for not applying the Bosporus presumption in the EEA and to the EFTA court really sticks. And the primary justification is, the way I perceive it, is the fact that within the EEA there is no direct effect and no primacy. And this is, of course, one of the biggest differences between the EEA system and the EU system from a formal point of view. But principles are not there for themselves. They are there to fulfill a purpose. The principles of direct effect and supremacy within EU law, they are not there for the sake of themselves. They are there to fulfill a specific purpose, and the way I perceive it, that purpose is to truly ascertain that European Union law is upheld at the domestic level. And the EFTA Court has developed other principles to ascertain that. Most importantly, what the EFTA Court has done, it has developed a strict principle of state responsibility, which holds and which requires that domestic courts hold the EEA states responsible for breaches of EEA law at the domestic level. The EFTA Court has also developed a principle of what one would call EEA-conform interpretation of EEA law, even though it's not implemented into domestic law. So it's a presumption that you have to interpret domestic law in accordance with EEA law, and that is a strong principle as well. And I say this because, and I will quote something that a friend of mine quoted this in the foreword of his PhD thesis I wrote together with him, and in the foreword it says, and he wrote about the principled reasoning of the Norwegian Supreme Court and how they developed principles. And in his foreword he said, "I'll show you my principles, and if you don't like them, I will show you some others." So is the question not really, well, the EFTA Court has provided some different principles than the European Court of Justice, but the result is the same? And if so, why should not the Bosporus presumption apply even though? So I'll leave it to that, and I'll open up for comments, reflections, and maybe questions from the audience, if any. At the back, please.
Thank you very much. Maybe that follows up to your comments, but in order not to hide, my understanding of the Holship case, at least as decided by the EFTA Court, is that it's a follow-up to the Viking case of the Court of Justice. So I wonder whether if the Viking case had come to the Court of Human Rights under the Prosperous assumption, would that have been different in result? And secondly, since, at least in my perception, it should not be and it could not be, in how far can we take the results from the Holship judgment of the European Court of Human Rights to apply in both legal orders, in the EEA and the EU? My answer would be yes, but I would be interested to hear your views on that. Thank you.
Thank you very much. If I may, and you have to understand that I need to be a bit cautious as to how I address your questions. But first, just some small follow-up elements from what Mikael said. First, it is clear that the fact that we have two different approaches, at least in principle, as to how we assess the conformity, respectively, of implementing EU law and EEA law by the member state, might create certain friction, because in the one relation, in principle, we have our scrutiny goes, in principle, to the very end, while we stay on an arm's length distance when it comes to the EU member state. That is, you might say, that is, we might like it or not, but that is the setup as it is now designed by these two, one decision and one judgment from the Strasbourg Court. If I may just add, this is not neither a prediction nor a promise, but I think we should be made clear that both in the first Bosporus case itself, but notably in the Avutins case, the Strasbourg Court also underlined the fact that this assessment, whether the Bosporus Doctrine applies to a particular international setup, is also a dynamic assessment. So there is nothing in this case law that would tell us this is how things will be for the future, for the eternity. And if I may be slightly open here, I tried very carefully to describe that there is actually already a bit movement if you compare Concurrenten with Holship, because Holship somehow questions some of the reasoning in Concurrenten and adds some new elements, and it is also explicitly stated that the court might want to revisit the question at a later stage. So there is already somehow envisaged the possible development. As I said, no promise, no prediction, simply just an analysis of what the sources tell us. Indeed, we might in principle again run the risk that the court might have to rule on what is basically EU law into the back door, but this is at least the construction as it is. As for the question regarding the Viking case, I need to be extremely cautious. But the last point I mentioned as to this statement by the Strasbourg Court as to how the normative configuration would play out is, you might say, this is not exactly what happened in Viking case. This is slightly different. And there is, I think we should frame this as part of the ongoing dialogue between European courts. One third point, if I may, somehow, again, we are struggling with the pragmatism of this setup because we have a lot of principles and we somehow we like to stay with them. We do not want to come up with a new set of principles. But it is also a matter of trying to solve the issues still in a pragmatic way. And there is, I think, the beautiful part of this, also from a pure legal point of view, the beautiful part of this is also that we are trying to achieve coherence, not only as for European EU law, but also when it comes to fundamental rights protection at European level. We see more and more how domestic courts apply our convention in interpreting their own constitution. This is, for example, in Norway. This has been established for quite some time, subsequent to the constitutional reform in 2014. The Supreme Court stated very early that in applying the new provisions in the Constitution, mirroring the European Convention, we would simply, or they would simply also then take into account, as we already talked about, take into account the case law of the Strasbourg Court. And then again, the European Court of Justice would also take into account our case law, and we would, on the other hand, take into account the case law from the Court of Justice of the European Union. And thirdly, we would, when we apply the Convention, also take into account a comparative panorama of constitutional law practice in the member states. And of course, the ultimate goal would have to be avoiding the situation where the fundamental rights protection somehow goes in different direction. And to the extent we do that, all these principles and difficult ways should still not lead us to the complications. But it requires, it requires good faith, and it requires that we play the same game. And as far as that's the case, it's solvable, but it is delicate.
Anyone else? Yes, Gunnar Tore Pettersson.
Thank you very much. I was actually not going to ask a question, but might come back to this during our presentation. I might have to adjust it, but depends on the answer. There was this one issue that was highlighted in Bosphorus among the evaluation of the EU legal order, that is judicial review or annulment through a specific procedure or through preliminary rulings. That was not really stressed neither in Concurrenten nor Holship. What weight should we put on that, and given that, let's say, there is no similar process on the EFTA side, at least not in principle when it comes to reviewing EEA legal acts.
There's another question in the middle, please.
Well, it's less of a question. It's more a contextual. It's more of a contextual remark from the Court of Justice. I just wanted to mention that on the Bosporus saga in a wider sense, and of course our decision 213, there is some recent jurisprudential evolution of the Court of Justice in two recent judgments, KS and KD, and in Neves 77, we had to consider the question of the extent to which our court, the European Court of Justice, is exempt of jurisdiction on matters of foreign and security policy. The court has, without going into any detail, has undertook quite a major operation, which brings us rather close in the conclusion to what the Strasbourg court is already adjudicating for quite some time in those delicate questions. So I think this is a very important movement which might even lead to further consequences. At least this is what is not excluded by that jurisprudence. And if I have the floor for a second, there will be another judgment to come out on 4th of October, which is in the Avotins line, so to speak. So it's again a question of recognition and fundamental rights in the question of freedom of the press, which is a very delicate issue for the Strasbourg jurisprudence as well. So there is something to read. Thank you.
Should we take maybe one or two more comments if there are, and then let Arnfinn sum up before we take a coffee break? So if anyone else wants to take the floor, if not, then we will let Arnfinn finish with commenting on these last two ones, and then we will have a deserved coffee break afterwards. Thank you.
Thank you very much. As for the first one, the procedural setup and the Bosporus, I simply should limit myself, I think, to referring to paragraph 108 of the Strasbourg Court's judgment in Holship, addressing in particular the question of to what extent would any kind of difficulties or deficiencies when it comes to the procedural setup somehow impact the assessment of the applicability of the Bosporus doctrine. Here, the court said, initially I planned to cite this, but then I started to read it and I realized it's quite difficult to understand. So, but I take no responsibility, but this is what it says. However, given one of the other features of EA law identified by the court in the Concurrenten decision, the absence of supremacy and direct effect, added to which is the absence of the binding legal effect of advisory opinions from the EFTA Court. And given that the existence of procedural mechanisms for ensuring the protection of substantive fundamental rights guarantees is one of the two conditions for the application of the Bosporus presumption, the Court leaves this to another case where question in relation to the procedural mechanisms under EA law may arise to review this issue. It's not a good answer, it's the answer, and for the time being, it's the only answer I can give you on that one. I would then end by thanking immensely for my good colleague bringing up the very recent development in the case law of the European Court of Justice when it comes to its competence. There are many reasons to somehow celebrate this development as seen from our perspective. Of course, it's not going into details, but there is there is an opening in that approach that would somehow might become useful for the future cooperation between our two courts. And I also noted with great interest that the approach taken by the Luxembourg court as to the fine-tuned level of scrutiny, it somehow mirrors what we also from time to time try to achieve. And I'm quite convinced that we will be able to, in the long-term perspective, to connect the two traces so that this could play well together. And that's, I think, probably a very good end note from my side. Thank you.
And I agree. So that leaves us to the coffee break and to give you our sincere thanks for this fascinating contribution and to all the participants. So we will take a coffee break until 11:30, I think, and then we start up again. Please try to be back in time, 11:30. Yes, thank you very much. We're a bit delayed, but I'm quite certain it's not justice denied on this occasion. So, the next speaker is Thérèse Planchet. And to most of the audience here, she should need no further introduction as the last speaker. She has had an extraordinary career, in particular within the Council of the European Union, where she since 1995 has occupied a number of important positions such as legal advisor in various capacities, Director of the Justice and Home Affairs and Director General of the Legal Service of the Council, and currently and since October 2022, she is the Secretary General of the Council. Through this, Thérèse, you have of course gained the most profound knowledge of the workings of the European Union, both from a legal and a political perspective, I would say. But we are happy that Thérèse, she has not only profound knowledge about the European Union and the workings of it, but also of the EEA and the EEA agreement. And this is not least so because she, between 1990 and 1995, was a legal advisor in the EFTA Secretariat. And during that period, she participated actively in the negotiations of the EEA agreement, and as the President said in his opening speech, she was indeed present at the signing of the EEA agreement. Thérèse, you have also written academically about EEA and EU law, and I would particularly like to mention a book on the EEA agreement, on the free movement of goods and competition rules, which you wrote with Risto Pipponen and Maria Westman Clement, published by Oxford University Press in 1994, which I still find very useful. Through your work, Thérèse, you have of course been closely associated with many of the treaty revisions of the European Union. And your speech today here, I suppose, also to some extent concerns revisions of treaties, but maybe more so, not the treaties of the European Union, but maybe more so the EEA agreement in itself or its associated agreements. We will see. In any case, you will ask the question whether the EFTA surveillance and judicial pillar could be extended beyond the EEA. You have informed me, Thérèse, that you will keep your speech relatively short, so that there will be plenty of time for reflections and discussions. So please do not hesitate to take the floor and discuss and reflect with us afterwards. And when you do so, please state your name and the institution you are representing. Okay, Thérèse, the floor is yours.
Thank you very much. Thank you very much, and also for inviting me here with you all, honorable judges. I'm very honored to see you here with us, of course, to celebrate your court, who has been there for 30 years. A very successful court, as was said several times, including by the first speaker, the President of the Court of Justice. I was with you 5 years ago in an EFTA court lunch discussion in October 2019, asking whether one could take advantage of this successful experience of the EFTA court to do more beyond the EEA. In other words, whether the EFTA court could indeed be allowed to wander into the streets of Schengen, Dublin, and other parts of the EU acquis in the area of justice and home affairs. Whether it could, the EFTA court could even be allowed one day to wander into the more hilly pastures of the many agreements that the EU has concluded or could conclude with Switzerland, pastures which, as we know, have their ups and downs. The fact is that the EU and the EFTA states have developed their very close relationship in two parallel paths, as President Lennart underlined also this morning. It's always forgotten that, I mean, we have the EEA in mind, but we forget the rest. So the economic path with the European Economic Area, and for Switzerland, this web of bilateral agreements, and the justice and home affairs path with the association of the 4 EFTA states, so including Switzerland, to the Schengen and the Dublin Acquis and a few other instruments such as, for instance, the European arrest warrant, which is called surrender in this particular agreement with Norway and Iceland. So these two paths have developed separately with their own specific institutional and governance mechanism. The EEA path started 30 years ago, as we by now know. It extended the internal market to the EFTA states in a very unique way. Having voted no to the EEA in 1992, Switzerland started more than 20 years ago, in 2002, its own specific path of multiple bilateral agreements. At the time, the Swiss chief negotiator of the EEA, the late Franz Blankart, compared the path of bilateral agreements compared to EEA to trying to reconstruct a Rolls-Royce with spare parts. He was a little bit sad, of course, for what had happened in 1992 in the referendum. So the justice and home affairs path, on the other hand, started almost 25 years ago when Iceland and Norway signed in 1999 their association agreement to the Schengen area and the Dublin Acquis. Switzerland and Liechtenstein joined a bit later. Why did Iceland and Norway do that? Because obviously the Nordic countries of the EU were joining Schengen, so there was no way to start to separate those Nordic countries from each other, because they had themselves a sort of mini Schengen between themselves. So, I mean, it was logical to bring everybody together. There was even a specific protocol in the treaty of the EU about that. Schengen, which is, as you know, 30 minutes from here, a very nice village by the Moselle River at the crossing of 3 borders between Luxembourg, Germany, and France. Next year, we will celebrate 40 years of the signature of the Schengen Agreement in June 2025. So it was in 1985, the signature, the first agreement. Then there was the implementing agreement, a bigger agreement of Schengen. So the EEA agreement is about the internal market, and the Schengen is like the blood of the internal market. It is about allowing people to circulate freely without internal border controls, regardless of their nationality. That's the whole thing. Because the Single European Act removed the borders for goods, but kept the borders for people at the time. You needed to differentiate between the citizens of the EU who could freely cross the border and the non-EU citizens who had to be checked at the border. So that was the whole issue of Schengen. As we very well know and rediscovered during the crazy days of the COVID crisis, it so happens that lorries are driven by people. If they can be stopped at each border to be checked, then very quickly it creates chaos all over the place and long lanes of trucks. 100 kilometers of trucks waiting to enter at the time Poland, you know, in the middle of the crisis. So that's what they wanted just to go to the Baltic states. So I'm not even talking about the thousands of, tens of thousands of frontier workers who cross borders every day, including this very border that we were talking about, very close to here. And we know that Schengen is having a little bit troubles, has been having troubles for the last 10 years, actually. And we see here and there reintroductions of internal border controls a little bit in a wild way, I would say, these days, unfortunately. But for that to work, meaning no internal border controls on persons, for enabling this absence of internal border controls, we need what in the Schengen jargon is called compensatory or complementary measures. We need to move the controls on persons to the external borders in order to free the internal ones. And we need to have common rules on visa, on asylum, and also common rules on police and judicial cooperation. This is why this Schengen Implementing Convention contained about 30 articles, a whole chapter on police and judicial cooperation in criminal matters. Law enforcement authorities cannot be blocked by borders that criminals and their activities could be freely crossing. That's the whole idea. So this police and judicial cooperation part is a very important component of the good functioning of Schengen, actually. And they have been a little bit separated by the fact that the UK was also a member of the EU at the time and was interested in its police and judicial cooperation, while it was not interested in the opening of the internal borders. So this is why there was this sort of separation at birth at this moment. But the source of all this cooperation is still in the convention, the Schengen Convention, and could have been developed simply as the Schengen Acquis, as a development of the Schengen Acquis. It was meant to be like that, but it was separated because of the conditions of the time. Like Dublin was also a part of the convention, because it's inherent to the system of Schengen, but it was a little bit separated at birth because the UK wanted to profit from Dublin, not from the opening of the borders, but from the Dublinizing the people to the other countries, of course. So that's the whole, and it's still the question for them, of course, they will not get it. So this link between the absence of internal border controls and the necessary compensatory measures is clearly expressed in the very wording of Article 3, paragraph 2 of the EU Treaty, when it says that the EU shall offer its citizens an area of freedom, security and justice without internal frontiers, in which the free movement of persons is ensured in conjunction with appropriate measures with respect to external border controls, asylum, immigration, and the prevention and combating of crime. This, what I was telling about the spirit of Schengen, is there in the article of the treaty on the objective of the treaty. This is why there are very powerful police cooperation, law enforcement, and judicial cooperation instruments in the EU that have been developed over time. The well-known Schengen Information System, the European Travel and Information Authorization System, ETIAS, which will enter into application in 6 months, about 6 months, the Entry-Exit System, which will enter into application in this autumn, after having been a little bit pushed away because of the Olympics. Would have created too many issues. The European Asylum Fingerprint Database, Eurodac, which is part of Dublin. The European Criminal Record Information System, ECRIS. The System of Exchange of DNA, Fingerprints and Vehicle Registration Police Data, which is known as the PRUM Acquis. And the Passenger Name Record System, PNR, also. So these are all very powerful, but of course, risky for fundamental rights, so need to be, controlled instruments, which are absolutely necessary for the good functioning of this border-free, internal border-free area. There are also police and judicial cooperation instruments, such as the all-powerful Europol, Eurojust, the European Arrest Warrant that was mentioned, and the European Investigation Order. So these are all very powerful and efficient cooperation instruments that are necessary complement to the Schengen free area. Norway and Iceland do apply something very close to the European Arrest Warrant, as we have seen, the Surrender Agreement, which was signed in 2006, but took 13 years to be ratified. It's now in force since 2019. The 4 Schengen associates also apply the PRUM Acquis, or will be applying soon the PRUM Acquis. There are still some ratification, I think, going on DNA, fingerprints, and vehicle registration. And there is, all of them have cooperation agreement with Europol, but these are the normal cooperation agreement. They don't have a plus, something plus. They would like to have something plus, meaning accessing to the huge, also very powerful Europol database. But this takes a little bit of effort. I mean, it cannot be only one-way street. Hence, the suggestions that the ideas that I'm supporting in terms of the EFTA Court role in this area of justice and home affairs and Schengen. There is a wish to cooperate more closely on those powerful instruments which are essential complements to Schengen. But we have to admit that when it comes to the institutional and government setup of these 2 separate paths, EEA and Schengen Dublin, the differences are quite striking. The EEA has a very sophisticated system of governance based on the famous 2-pillar system, as we have seen. We have heard about it, and the kind of competencies that the EFTA Court has, also the kind of competencies that the EFTA Surveillance Authority has, like the Commission on the surveillance part of the Commission, of course not proposing legislation, but on the surveillance part. On the other hand, the decision shaping in the EEA from 30 years ago is far less sophisticated than the Schengen association system. The EEA agreement for the decision-shaping part provides that the Commission should informally consult the 3 EFTA states upstream when preparing future proposals in the same way as it consults member states, that the EFTA experts may participate in the famous or infamous comitology committees, well, many, which are presided by the Commission. But EFTA experts representatives do not cross the road to the building of the Council, where EU member states meet every day. So that is the shaping of decision-making in the EA is very much ex ante, but not afterwards. Once the proposal is on the table of the co-legislator, that's it. If I may say so. I know, because we negotiated it at the time. We found that it was a great achievement, and I'm telling you, this decision shaping, but what we have seen that what has developed afterwards, of course, you may consider that it could be improved. But by contrast, this is where the comparison comes, the level of association of the 4 EFTA states to Schengen decision shaping is very unique and specific, and make a lot of people envious, of course. After upstream consultations like the EEA, the big novelty and difference is that once the proposal has been formally submitted to the EU legislator, the representatives of the 4 EFTA states are closely involved in the decision shaping, not making, shaping, through the mixed committee. We called it COMIX in abbreviation in our documents. This committee meets in the Council building with Council members and Commission representatives at the 3 levels of the usual meetings of what happens in the Council building: experts, so working parties, ambassadors, so co-repair, and ministers, interior ministers concerning Schengen. So there is even something called, they call it a Schengen Council to make it more sexy, but actually this is just the comics meeting as it does, back to back with the EU 27 meetings. So actually, in reality, to be very honest, the real discussion is in the comics with the Schengen associates, and then afterwards, the back-to-back is the other way around. In practice, the EU 27 meeting without the Schengen associates in the room confirms, etc., what has been discussed. But the decision-making, the adoption of legal acts is, of course, done only by the EU side in co-decision, the Council and the Parliament. So this is the difference of system. This is asymmetric, as we see. A lot of, very sophisticated control system in the EEA, but a very sophisticated decision shaping in the Schengen part. Because the Schengen setup, as we have seen, is quite poor when it comes to governance. Quite very poor, actually. It only provides that the mixed committee, the famous mixed committee, should keep under constant review the development of relevant case law and secure uniform application and interpretation, so a political body. And I can tell you that it very seldom happens. I have never seen it happen in the 7 years I was in the JHA part of the legal service. So, wow. And it provides for a classical dispute settlement system in the event of divergences or dispute, or in case an EFTA state would not take over a piece of acquis that it is supposed to take over. But then the process is, apart from this political thing, which barely happens, is a very violent one, because there is this guillotine clause. If you don't behave, you will be kicked out. So it's a bit brutal for such a close and sophisticated system of association as Schengen. So we could perhaps try to solve this, or improve or decrease this imbalance and improve the balance of the system by trying to take advantage of the successful surveillance and judicial EFTA pillar of the EEA, which we have heard of very much this morning. The EEA has allowed these EFTA states to be part of the internal market, while safeguarding the sovereignty, the integrity, the autonomy of both the EFTA and the EU sides. With this two-pillar system, it has also ensured the correct application of internal market rules, the fact that it is overseen by independent institutions, which is very important, as we have heard. Like the EEA, the Schengen Association Agreements do safeguard the respective autonomy and sovereignty of their respective partners and allow for dynamic evolution of the acquis, like the EEA. But these agreements lack these Schengen agreements, they lack this decisive element of having a mechanism that ensures the correct application overseen by independent institutions, and that the rights of people are safeguarded then. Given that an efficient and independent oversight is fundamental, as we heard from President Lennartz, a fundamental tool in order to build and protect mutual trust, which in turn is a prerequisite to the good functioning of an area without internal border controls, like Schengen, this weakness should be, if possible, corrected. A rather simple and straightforward way could be to use this system, what has been dubbed as EFTA pillar docking, meaning that the Schengen, Dublin, and perhaps all the JHA could be docked to the EFTA surveillance and court system. As we know, these EFTA surveillance and court systems, they have been created by a separate agreement between the EFTA countries. So the same EFTA countries plus Switzerland, if they would add another, but that I will just mention it en passant afterwards, but it's a complicated element, so I will concentrate on the EFTA states, the three of them. They could dock themselves to this by adding a protocol, for instance, or let's limit the amendment to the minimum needed. That's always better, by experience, to this agreement by adding extending the jurisdiction of the EFTA Court to cover those agreements, the Schengen, the Dublin, and the JHA area agreements that will perhaps build up in the future. Because if we improve, I think, this surveillance and the control system, it will create more trust between the parties, and I think the EU member states would be more ready to extend more JHA acquis to the EFTA states, which will be in the interest of the whole area, as we have seen. So that could be, I think, a possibility, which could be digged more, and then, as a consequence, perhaps the EU states would be more generous in terms of perhaps improving the decision-shaping part of, the whole of it. I don't know. It's just it's a tit for tat in a way, but I mean, a negotiation is a two-way street. So perhaps it could be considered, this sort of improvement on both sides. Given that Switzerland is also a member of Schengen and Dublin, theoretically, the geographical scope of a protocol, and the advantage of a protocol could be that it's a bit of a, like that, could be extended to cover also Switzerland as regards their agreements. I know that they are negotiating something else now, arbitration with question to the Court of Justice, it's not finished. But also, more importantly, for Schengen and Dublin and all this acquis that is really applicable in a dynamic fashion in Switzerland. So, but okay, then the college of the EFTA Surveillance Authority would need to have two colleges, and the court perhaps two chambers. It's a bit complicated, I fully understand, but it's theoretically, as a lawyer, of course, it can be drafted. All these possible options, of course, they need political will, political decision. Sometimes ideas, they prosper over time. Sometimes it's easier to stay as we are because it's more comfortable in known territory. But I think that it would be good both for the EU side and for the EFTA states, who are so integrated also through Schengen, to forget about this past that was provoked by actually the fact that the UK wanted this separate development, to make it more consistent and cement the whole thing together. Because as has been said, in the times where we are, and I see it when I am with the heads of state and government, because this is also part of my job to sit there with them, the gravity of the geopolitical situation in which we are is pushing us to glue to each other even more and more and more. I mean, this is the only way, I think. So this should be, you know, the political side of it. I'm pretty sure they understand that aspect. That's their role. Thank you very much. I hope I was not too long.
No, that was good. Thank you ever so much. I will allow myself one comment before I give the floor to the audience, if anyone wants to comment or reflect or say something. And you said perhaps this is something that could be considered, and perhaps to provide the EFTA court with jurisdiction to deal with some of these issues. And from the point of view of the EFTA court, I would say we have recently pronounced ourselves on this. There has been a hearing in Norway on a new report on the status of the EEA agreement in Norwegian society, in which it was proposed to do so, to expand the EFTA court's jurisdiction in this regard. And the EFTA court responded to that and said, yes, this should be considered. And the reason for it is, and I'm not going to talk about the political issues, is this, in this whether it should be wise and whether one should do it, but the reason, seen from the point of view of the EFTA court, is more legal. And a bit technical, but I think it should be understandable to all of you. And I will start to look at how the Court of Justice of the European Union deals with these questions when it comes to them. And these questions, which concerns people moving over borders, whether it's under the Union Citizenship Directive, whether it's in the free movement of workers, etc. And when they raise Schengen issues or arrest warrant issues, the European Court of Justice, they don't separate between whether it falls within the Schengen agreement, whether it falls within the European arrest warrant, or whether it falls within the Union Citizenship Directive. Easily put, they have to consider it all together and come out with a solution. One solution. But the EFTA court is prohibited from doing just that, because we don't have jurisdiction to deal with the Schengen issues. And this may, of course, cause complications and prejudice the goal of homogeneity. As President Lennertz talked about this morning. So far, this has not happened, and we do our utmost for it not to happen. But the question is there, and that's the perspective of the court, and that this is something that should be avoided. Okay, thank you for allowing me to bring that out, and then I open the floor for comments and reflections from the audience. Yes, please state your name and the institution which you're representing. Thank you.
Thank you very much. My name is Árni Páll Árnason. I'm Vice President of the EFTA Surveillance Authority. And thank you for a very interesting statement. Very interesting for us to also hear that you talk about the internal market and Schengen providing the blood for the internal market. We could draw rather not very nice conclusions from that, which is basically that we are dealing with a dead body because we don't have the blood. But drawing on your thoughts, and maybe just rather a reflection than a direct question, when we are looking at homogeneity, and I take your concluding remarks as sort of being appreciative of the idea of uniting the whole structure in one way. I want also to draw attention to areas where we see disparities that persist, which are very difficult for us to deal with and actually impossible for us to deal with. We see, for example, when it comes to enactment of legislation, the EFTA states, of course, the EFTA states enjoy a privileged position in the sense that they have to approve in a joint committee decision what applies within the EA, and that can take years and years. And
then they get a certain time to implement. And then, of course, we do not have the powers in the EFTA Surveillance Authority that the Commission has to fine member states for lack of implementation and for not implementing legislation, which provides I would say, a great risk of the states simply waiting us out. So just adding this simple example, these simple examples of the disparities we are faced with every day in our work to the whole mix, and also bringing then forward the idea this is of course within the gift of the member states themselves to decide to change a structure like this and implement in a different way through their own mutual agreement, through the surveillance and court agreement, and remedy deficiencies in the structure in this way. Thank you.
I think we will collect, yes, please.
I'm Fredrik Sejersted. I used to be a professor of European law. I chair the 2012 Norwegian Europe Review Commission. And for the last 10 years, almost 10 years, I've been the Norwegian Attorney General of Civil Affairs, which makes it necessary for me to say that what I'm going to say is just personal opinions, not reflecting the position of the Norwegian government in any way. So having said that, Madame Blanchet, I thought your speech was very interesting on an analytical, academic level. I will come back to whether it's practical or realistic, but it was a very interesting idea. And I think I have two observations and one question. The first observation is that, as your introduction really highlights, from the perspective of Norway, and I'm sure Iceland and Liechtenstein as well, and Switzerland, we still tend to see the European Union in the old three-pillar system. It's the first pillar with the internal market, that's the agreement. It's the second pillar with justice and home affairs, and it's the third pillar with foreign policy and security and defense. And we have talked about the EA agreement, which is what we are here for. You have talked about the second pillar, justice and home affairs, Schengen and Dublin, etc., 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 etc. We should also be aware that most of the action at the moment, seen from the Norwegian perspective in European policy as regards the relationship to the European Union, is in the third pillar. This is where it's happening at the moment. We have for a long time been signing agreements on security, defense and foreign policy, and as late as this spring, we signed a kind of framework agreement with the European Union on defense and security. More like a memorandum of understanding, but still, it puts together all the different bilateral and multilateral agreements that we have in that pillar, and that is where the political focus is at the moment, not so much on the other ones. We should be aware of that. Just as this is just an observation. As regards, and I will not talk more about that but that is really where my heart is at the moment in the third pillar, and Norway, and I'm sure Iceland's relationship to the EU on the third pillar which also requires a lot of legal and political momentum and decision making. As regards the second pillar, of course, we had this Dublin Schengen setup since the late 1990s, and what you are proposing, in my view, is not a minor technical regulation of jurisdiction of the EFTA court. It's a very major step in principle and in practice. I think it would be very hard to make it, but it's very interesting, and we can start thinking about it. Because as you know perfectly well, in the mid-1990s, when the Schengen came up, there was a deliberate decision not to put it into the EA agreement, but to keep it as a separate setup for many reasons. And this has been the way afterwards. And we have signed, you mentioned some of the treaties, the Europol, the Eurojust, the European Arrest Warrant, the PROM, etc., etc. Seen from the Norwegian perspective, and I'm sure Icelandic and Liechtenstein as well, and Swiss, this is a patchwork. And it takes a lot of time, it takes a lot of effort. We signed the agreement, it takes 12 years to get them ratified, and it's slowly entering. But we are participating in a lot of it. And it's not under the surveillance of the authority, and it's not under the jurisdiction of the EFTA court. To change that, to put the old second pillar, justice and home affairs, under this jurisdiction would be a very major step. I think it's a very interesting idea. It's also very interesting if you are sending a signal that would make it easier for Norway and Iceland and Liechtenstein to substantively get into these agreements and to get better agreements. And from a legal perspective on legal certainty and procedural rights, etc., judicial review, of course, is an obvious fruit to pick. But we should not underestimate it. Would require a lot of legal thinking. It would require a lot of political backing, which I don't see at the moment. That would have to be fostered. And it would require some quite major technical drafting of agreements. And this is where my question comes in, because I was trying to figure out what would we have to do in order to make this happen. And if I understand you correctly, because you have three sets of, you have the EA agreement, then you have the EFTA agreement on the surveillance authority and the court, and then you have the, I don't know, over 15, 20 bilateral, multilateral agreements on Schengen, Dublin, Europol, Eurojust, arrest warrant, so on and so forth. So if we see that as three categories, what you are proposing, it would maybe not require an amendment of the EA agreement, but it would definitely require an amendment on the EFTA surveillance and authority agreement. If I'm just thinking aloud now, but it would probably require a framework agreement around those parts of the justice and home affairs which we wanted to include. A kind of, it would put Schengen, Dublin, arrest warrant, whatever, into a kind of framework agreement. And then with a mechanism. And if it was, of course, this is not a small matter, it would dramatically increase the surveillance competence and of the EFTA surveillance authority. It would change the EFTA surveillance authority dramatically, and it would change the EFTA court quite a lot. So this should not be seen as a small matter. This should be seen as a very big proposal, which is at the moment academically very interesting. I think we should think about it a lot, but we should not underestimate the fact that the whole political backing for such a process, at least in Norway, I'm sure in Iceland and Liechtenstein, and in the European Union, would have to create something which is not present at the moment. Thank you. And this is just my personal reflection.
If there is one more comment, I think it has to come now, and then we let Therese close afterwards. But so I look around and I see nothing, then I'll let you close now, Therese, and we'll take lunch afterwards. Thank you.
Thank you very much. On the first intervention concerning the time it takes to take over acquis, well, the whole EEA beauty is in its dynamism, and that's the thing that is being discussed also with the Swiss part being in the EU and the Swiss now, with this rebirth of the yet another negotiating period. But yes, I think that if it takes, it's for you, of course, you are the surveillance authority. If it takes an amendment to the, I don't know, to be honest, to the EFTA surveillance authority and court agreement, EFTA court agreement, to add some more powers to the EFTA surveillance authority to give it more teeth, to push a little bit the states, the EFTA states who are dragging a little bit their feet, I don't know, into adopting the or aligning or taking over the acquis. That's for your internal matter, but it is true that this may create an imbalance and a difficulty of, I guess, of functioning of the EEA, I mean the internal market in these circumstances. So perhaps also and there are, okay, the joint committee can discuss it, and the machinery a little bit of this sort, pressure, political pressure can be triggered, I guess. I'm not going to the guillotine, but I mean that's a bit the idea. As I said, in the Schengen, it's rather radical, you know. But I fully agree and I fully support you, because we should not, the EEA agreement is a very successful agreement, very silent, nobody knows very much about it, it's living its own life in a very smooth and nice way. But if there are issues where it doesn't work, or there is this sleepy kind of, oh, on dort sur nos lauriers, it should be raised politically, including, of course. But there is a build-up to these sort of things, of course, normally. On your very interesting intervention, thank you. Of course, I don't underestimate the difficulty. I didn't have any idea about, polluting the EE agreement with Schengen acquis being incorporated into it. This would be impossible to do. But the Schengen association agreements, they are quite, they are quite developed. They are functioning well. And I think that we could start by this. Before the surrender and all the other. Perhaps we could start by the most integrated ones, which are the Schengen-Dublin agreements, which are well-functioning, and it's quite easy. The acquis is quite identified. I mean, everything is clear about what is applicable in the Schengen states, EFTA states including. So I think it could be a good way to start because of this very close link with the internal market, as we were all underlining. I don't underestimate the difficulties. For the future development, there is also some thinking in Brussels that in the legal service of the Council, for instance, and in other circles, that perhaps we could think about Schengenizing a number of pieces of acquis, actually, to simplify, because it comes to discover. It avoids to have all these different agreements around the Prüm, machin, with each time a different setup. If you Schengenize, because these are necessary for the functioning of Schengen, they have been separated at birth for the reasons that I was telling, but there is no reason to continue with this separation in a way. So if you Schengenize it, you qualify those instruments of justice and home affairs, EU law, as Schengen acquis. They enter into the system. You apply to it the decision shaping, very intense decision shaping of Schengen to these. And you also, by the way, solve the issue of Denmark because they are being kicked out as it comes because of their very strict opt-out from all the, each time you amend an existing JHA instrument of the EU where Denmark is already. If we would, for instance, amend the European arrest warrant now, which we will not, I think, touch, but if we would do that, replace it to amend it, Denmark could not participate in this. They could be kicked out of it, which would be a disaster. So if you Schengenize this, if you call Schengen acquis all these police cooperation instruments, even Europol could be Schengenized in a way, and judicial cooperation instrument, talking about criminal law, judicial cooperation, that could, solve one thing with one shot. With one shot, you solve several problems. That's an idea to be discussed. Not easy, a lot of resistance, etc. But if you think about solving this separation at birth problem that we had at the beginning, perhaps it could be a way. So things could, meet together nicely in the EFTA court, in the EFTA Service Authority, which would need to be reinforced a little bit. It takes a bit of budget, of course.
Yes, thank you. I think that's a quite good line to close this session on. So Therese deserves a warm applause, and we deserve lunch. There will be lunch downstairs, and we meet back here at 13:30. So that's a bit over an hour. Please try to be on time again. And a warm applause to Therese.
yeah.
It's like at the university.
It does. I hope that they're paying more attention than, I mean, some of the backbenchers that they, it's always the first rows to see that they're sitting like lit candles, and then in the back they're doing their own thing.
Thank you very much for, in a way, coming back in good time for our afternoon session. First of all, again, Excellencies, ladies and gentlemen, dear colleagues, dear friends of the EFTA Court, and especially a very warm welcome to all our former judges of the EFTA Court, former President Karl Baudenbacher, Henrik Bøhl, Turger Olesen, and of course, Per Christensen. Thank you very much that you joined us on this very special occasion. And perhaps the topic which I've chosen late in the afternoon about our 10 most interesting cases could indicate that I could address a question to you. So be prepared for that. But now we begin with our plenary, now with Hilde Ellingsen. It's for me a very great pleasure to introduce her. Hilde is a partner at Lund & Co. and an associate professor at the Center of European Law at the University of Oslo. She undertook her legal studies at the University of Oslo and New York University Law School, and obtained her PhD from the University of Oslo, writing her dissertation on the judicial enforcement of EU law by private parties, the impact of European Union law on domestic standing doctrines. In Hilde's 2021 monograph, Standing to Enforce European Union Law Before National Courts, published by Bloomsbury, she observed that the EU seems to convey the message that it desirable ensure an effective private enforcement regime, while avoiding excess litigation, and that there is an inherent tension between the ambition to more private enforcement claims being brought and the desire to avoid a litigation culture. With that in mind, Hilde is therefore perfectly pleased and placed to address us on the topic effective judicial protection under the EA agreement. Please.
Thank you. Thank you. So thank you so much for these kind words of introduction, and also thank you so much for the invitation to speak to you here today. So the topic of my presentation, effective judicial protection under the EEA agreement, it relates to the very core of fundamental rights protection in the EEA. And this 30 years anniversary, it provides us with an opportunity to reflect on the role of the EFTA Court in ensuring effective rights protection in the EFTA pillar of the EEA agreement. A key aspect of the EEA agreement is that it confers rights on individuals. And without adequate enforcement mechanisms, these rights would be rendered mere paper tigers. And this means that the proper functioning of the EEA agreement depends on the ability to rely on these rights. The principle of effective judicial protection is seen as an aspect of the EU constitutional architecture. And the ECJ proclaimed already in the 1980s that the principle constitutes a general principle of union law. Upon the entry into force of the Lisbon Treaty, the principle acquired the status of primary law in the Union. And Article 47 of the Charter prescribes that everyone whose rights and freedoms guaranteed by the Union are violated has the right to an effective remedy before a tribunal. And the right to effective judicial protection also entails certain due process guarantees and the right to a fair trial. And this transformation of the Charter into primary law has had an impact on the protection of rights by serving as a stepping stone for the evolution of the ECJ case law in the field of procedures and remedies at national level. So what we've seen is a more developed and forceful principle of effective judicial protection. Moreover, we're not only dealing with a principle, but a self-standing right. And the ECJ has held that Article 47 of the Charter must be seen as sufficiently unconditional and precise, so as to be able to rely on without implementing legislation, even in horizontal disputes. Moreover, in the past few years, we've also seen developments in EU constitutional law, with the principle of effective judicial protection being used as a gateway to enforce the rule of law in the Union. And the ECJ stated that since the member states are also functioning as European courts, they need to meet certain fundamental requirements, inter alia pertaining to independence. So just as in the EU legal order, the judicial protection of individual EEA rights works in a decentralized legal system where national courts effectively function as courts of European law. And the EFTA Court has recognized effective judicial protection as a general principle of EEA law. Yet since the principle lacks an explicit legal basis in the agreement, it has been constructed and developed based on considerations of homogeneity and loyalty. The legal developments at EU level still raises a whole series of EEA-specific questions. With the limited time available, I do not have time to dive into all the details, but I intend to touch upon three aspects of particular importance. The first pertains to the content of the principle of effective judicial protection. The second pertains to its scope of application in EEA law. And the third aspect pertains to its justiciability. First, with regard to the content of the principle, is there a full parallelism? Or are there differences between the two legal systems that entail a difference or an asymmetry between EU and EEA law in terms of effective judicial protection? The court, the ECJ, has stated that Article 47 of the Charter was of a codifying nature. Yet, an analysis of recent case law tells a different story. Rather, the provision seems to have been used as a vehicle for the evolution of the ECJ's case law pertaining to effective judicial protection. And we see that the court has taken a more elaborative stance, thus providing more detail on what this legal principle requires. In fact, we see that the ECJ has gradually moved in the direction of harmonization in order to ensure effective judicial protection of union rights. And it is evident from the case law of the ECJ that the principle of effective judicial protection encompasses both substantive and procedural sub-rights. And the principle may apply to a wide range of enforcement provisions, inter alia pertaining to access to court, due process guarantees, and also the remedies that need to be provided in the case of rights infringement. The evolution of the case law of the ECJ is most visible in cases pertaining to positive legal obligations, where the court takes it upon itself to define the measure that must be taken at national level to protect EU rights. And these obligations pertain inter alia to legal standing and the obligation to provide for judicial review of administrative decisions. And when developing these legal standards, we see that the ECJ has relied heavily on Article 47 of the Charter. So what does this mean for EEA law, where such a legal basis is lacking? The EFTA Court has repeatedly held that effective judicial protection is a general principle of EEA law. Yet, EEA law is not simply a carbon copy of EU law. Rather, it has its own structure and logic. The EEA legal order differs from the EU legal order in that its objectives are more modest and the depth of integration is less far-reaching. And there are also important differences with respect to the structural parts of the agreement and its effect in domestic law, and in particular as regards the required degree of penetration within the legal orders of the EEA EFTA states. And this begs the question whether these differences entail a difference in the level of effective judicial protection in the two pillars, or whether they can be bridged by considerations of homogeneity and loyalty. Homogeneity and loyalty are, as you know, key aspects of the EEA agreement. And the principle of homogeneity is not limited to the interpretation of substantive norms, but also applies to the legal effect of EEA law in the EEA EFTA member states. And the principle of homogeneity is also closely related to that of loyalty enshrined in Article 3 EEA, which requires the member states to adopt a positive obligation to implement all measures necessary to fulfill the obligations under the agreement, as well as a negative duty to abstain from any measures that could jeopardize the attainment of the object and purpose of the agreement. The EFTA Court has explicitly stated that access to justice and effective judicial protection are essential elements in the EEA legal framework, and also stressed the importance of equal access to courts in both the EU and EFTA pillars of the EEA. And the EFTA Court has moreover stated that reliance on the principle of homogeneity is needed in order to ensure equal access to justice throughout the EEA. And the court has made use of both homogeneity and reciprocity arguments to substantiate the claim that the level of judicial protection is the same in both pillars of the agreement. The scope and limits of the homogeneity principle is not set in stone. And as I see it, the EFTA court would not be acting ultra-vires and encroaching on the sovereignty of the contracting states by acknowledging that the principle of effective judicial protection also contains positive legal obligations. Insofar as the ECJ has created such positive legal obligations, these pertain to the very essence of judicial protection. It's not the case that the ECJ has engaged in extensive lawmaking, thus creating a form of jus commune. The EFTA court must, however, address the matter in a matter of effective judicial protection in the post-charter era in a skillful manner. And the EFTA court may rely on the Strasbourg case law in order to develop the content and scope of the principle. The ECHR is a source of law common to all EA states, and the EFTA court has stressed the importance of the provisions of the Convention, as well as the case law of the Strasbourg Court for the interpretation of fundamental rights in the EEA. The Convention rights may accordingly be used as a tool to align the standards of EU and EA law. And the notion of essence of rights also occurs in the case law of the Strasbourg Court, and as I see it, it should be uncontroversial to accept that it also exists in the EA context. As regards the scope of application of the principle of effective judicial protection, it bears repetition that the ECJ has used the principle as a vehicle for the enforcement of the rule of law at national level. The ECJ has used the principle, has required the member state to ensure that all national courts dealing with cases falling within the scope of EU law satisfy certain fundamental requirements, inter alia pertaining to their judicial independence. And this evolution has been made possible by reading Article 47 of the Charter in conjunction with Article 19 of the treaty, requiring member states to provide remedies sufficient to ensure effective legal protection in the fields covered by union law. And as a result, the scope of application of the principle has been broadened. The courts in all member states must meet these requirements of Article 47, not only when dealing with cases pertaining to union law, but also at a more systemic level. The EFTA court has not yet had the opportunity to express itself on the relevance of this strand of case law. Yet the court has nevertheless stressed the importance of having access to a tribunal that offers the guarantees provided for by the principle of effective judicial protection. And moreover, the court has held that the principle of judicial independence is one of the fundamental values of administration of justice. The integration of the EEA-EFTA states into the internal market was based on the premise that the level of judicial protection should be the same in both the EU and the EFTA pillars. And arguably, the constitutional and structural asymmetries do not extend to the foundations and values of these legal systems. It's stated in the preamble to the EEA agreement that the relationship between EU member states and the EEA-EFTA states are based on long-standing common values and European identity. It must keep in mind that the EEA agreement is an integral part of EU law, and EEA EFTA nationals thus benefit from the Union principle of effective judicial protection when exercising their rights. And the deficiency in the level of judicial protection in the EFTA pillar would be detrimental to the internal market, and it would affect the position of EEA nationals seeking to assert their rights. It would also put in jeopardy the special relationship between the EU and the EEA EFTA states as proclaimed by the ECJ in the case IN. The patchwork of agreements structuring this legal relationship is based on mutual trust, and also a trust in the legal systems of the EEA EFTA states upholding individual rights. The deficiencies in the independence and impartiality of the judiciary in an EEA EFTA states would undermine mutual trust and could in turn jeopardize the functioning of the EEA agreement. The question then is whether there is sufficient legal basis in the EEA agreement for extending the principle of effective judicial protection beyond the protection of EEA rights. Arguably, Article 3 EEA may entail an obligation to ensure effective judicial protection also at a more systemic level. National courts in the EEA EFTA states are part of a shared legal order, and they're entrusted with a European mandate. And this mandate requires them to establish a legal avenue through which EEA law may be enforced and EEA rights may be effectively upheld. Turning now to the matter of justiciability, it should first be stressed that the principle of effective judicial protection is, of course, binding on the legislature and the executive, in the sense that they have to establish a legal framework that complies with the principle of effective judicial protection. But what if they fail to do so? To what extent does this principle of effective judicial protection give rise to self-standing rights that may be invoked by the courts in the EEA EFTA states? The ECJ has held that Article 47 of the Charter is sufficient in itself to confer on individuals rights that they may rely on as such. Yet there's no provision in the EEA agreement that directly mirrors Article 47 of the Charter. The principle of effective judicial protection is just that. It's a principle. It goes without saying that a domestic court must make every possible effort to interpret national provisions in a manner that complies with the principle of effective judicial protection. And this follows from the obligation of consistent interpretation. But what if a possible conflict cannot be solved through interpretation? May an individual invoke the principle of effective judicial protection as a self-standing right? The EEA agreement does not call for the direct effect of EEA law in the domestic legal systems of the EEA EFTA states. Yet individuals may rely on provisions of EEA law once they have been implemented in the domestic legal order, provided that these provisions comply, are unconditional and sufficiently precise. But what then about a legal principle such as that of effective judicial protection? Would it be possible to invoke that principle by reference to Article 3 EEA? Does this provision satisfy the requirements of unconditionality and sufficient clarity? The ECJ has, in a series of cases, starting with Mangold and Kukukteveci, made clear that general principles of EU law are amenable to direct effect, also in horizontal disputes. Yet this has not been uncontroversial, and the Danish Supreme Court showed judicial resistance in the famous, or should I say infamous, IOS case, where they refused to accept this as a matter of national constitutional law. Applying the principle of effective judicial protection directly, in particular in a horizontal relationship, may be problematic from the scope of point of view of legal certainty. The alternative remedy for individuals would thus be state liability, making the relevant state liable for not fulfilling its obligations under EEA law. And this leads me to the final point of my presentation. Because the state liability doctrine, it provides an interesting case study on the effective judicial protection in the EU and EFTA pillars of the agreement. As is well known, in its landmark Frankovic ruling, the ECJ established that member states may be held liable when for damages caused to individuals due to infringements of EU law. And in Sveinbjørnsdatter, the EFTA court extended this principle also to the EEA agreement, stating that it constitutes an integral part of the agreement. The principle in the EEA law context was anchored in the homogeneity objective, in the principle of equal treatment, and also the principle of sincere cooperation. Whereas the EEA principle of state liability has been reaffirmed in subsequent case law from the EFTA court, a caveat has been raised with regard to the content of and scope of this principle. It has been held that since the principle has a different legal basis in the EEA and the EU, the application of the principles may not necessarily be in all respects coextensive. Under EU law, the principle of state liability applies not only to legislative and executive acts, it applies also to infringements committed by national courts adjudicating at last instance. And in Kubler, the ECJ held that member states can be held liable for manifest infringements committed by last instance courts. And to my knowledge, both the Icelandic and Norwegian governments reject the notion that state liability forms part of the EEA law. The arguments supporting this view relate to the special characteristics of the EEA agreement as compared to the EU. And the main argument seems to be that the state liability for the decisions of national courts constitute a sanction against national courts of last instance breaching its duty to refer preliminary questions to the ECJ. And then since there's no corresponding obligation in EU law, the argument is that national courts cannot be held liable for the incorrect application of EU law by national courts. Yet, as I see it, the differences in the judicial dialogue in the EU and EEA law legal order cannot be decisive with respect to the scope and application of the state liability principle. And the reference to the importance of the preliminary ruling procedure is based on the premise that the state liability doctrine constitutes a sanction for a national court's failure to refer questions to the ECJ. Yet, as the ECJ has made clear, State liability is not a means to sanction the state, but to provide compensation for individuals for damage suffered. A failure to refer a case to the ECJ, followed by an incorrect interpretation of EU law, may lead to the infringement of an individual right. Whether there has been a breach of the duty to refer is yet merely one of several arguments that must be taken into account in determining whether this constitutes a sufficiently serious breach of EU law. And it must also be borne in mind that the obligation to refer is not relevant in all situations. In accordance with the Silfit doctrine, the obligation to refer applies only when the legal situation lacks clarity. A judicial breach is in any event sufficiently serious if a national court has manifestly disregarded the applicable EU law, including relevant case law from the ECJ on the matter. Consequently, a breach of EU law may also be manifest in situations where the obligation to refer is wholly irrelevant, because the point of law is already clear. And this means, as I see it, that the Kepler doctrine and the Silfit doctrine should be kept separate. Liability, according to Kepler, may arise in a variety of situations. A rejection of the state liability doctrine for judicial infringements would mean that the contracting states can never be held liable for judicial infringements, even when the national courts fail to comply or disregards existing case law from the Luxembourg courts. Just a few words to round up. The purview and limits to the principle of effective judicial protection within the EEA legal framework is less than clear. At EU level, effective judicial protection is seen as an aspect of the wider EU constitutional architecture. So the ramifications for EEA law of these developments at EU level are therefore rather uncertain. And it remains to be seen whether the EFTA court will develop its case law in a manner that fully reflects the ECJ's case law pertaining to the Charter, Article 47, and also Article 19(1) TEU. As I see it, the EFTA court would not be overstepping the limits of its legal mandate by interpreting the principle of effective judicial protection in a manner that reflects developments relating to the Charter. Protection of EEA rights is of paramount importance due to the decentralized implementation and enforcement of EEA law. Differences in judicial protection in the EFTA pillar of the EEA agreement would not only affect individual right holders. Bearing in mind the private enforcement constitutes an essential part of the EEA toolbox, it would also hamper the effectiveness of EEA law more broadly. Thank you.
Thank you very much for this, to bring us a little bit closer, a very complicated topic, which in a way we are confronted with again and again, but perhaps it's worthwhile actually to invest a little bit more of our resources. And that brings me to my first question. That, you see, if I get once the privilege as moderator to be the master of the microphone, you have to bear with me that I get first my questions out. Sorry for that. I have two questions for you. On the one hand, I was wondering if the EFTA court has not already somehow embarked on this kind of avenue in the last year's decision in RS versus Liechtensteinische Steuerverwaltung, where there in the paragraph 50, I can cite this paragraph, the court held that in circumstances such as those of the main proceedings, it is inherent in Protocol 35 EA that the national court must give full effect to Article 28 EA and disregard any national rule or case law maintaining the legal effects of legislation that infringes Article 28 EA as such a limitation is not compatible with the EA law. So very clear language with respect, in a way, the obligation for member states. Would you conceive that kind of wording, something supporting your argument? Thank you.
Thank you. So the case you're referring to relates to the principle of supremacy, that you need to apply Article 28 in a concrete case and then set aside any conflicting measure of national law. And I think as regards the fundamental freedom, I think the EFTA Court's case law is well developed. Still, as I see it, it's still a problem that the principle of effective judicial protection is a principle rather than a hardcore right entailed in the concrete provision of the EEA agreement, which makes it somewhat more complex to grapple with this issue. So I'm curious if that case had come up with regard to the principle of effective judicial protection, whether you would have said the same based on Article 3 EEA. So, but I agree. I see that the EFTA Court is strong in upholding the principle of supremacy and also the principles pertaining to EEA-conform interpretation. So when you also gone quite a long way in accepting the principle of effective judicial protection and drawn on case law from the ECJ. So. But there are a few cases dealing explicitly with the development we've seen the past few years after the Lisbon Treaty and the evolution in the ECJ's case law.
The reason why I phrased this paragraph 50 is because it puts the national court, and that would mean the national judge, in a position to apply the EU law. So irrespective of actually the request, he's put into a position that it's up for him to put himself as an EA lawyer, and kind of an EA judge, to be precise. That would really shift him in the area of judicial protection. That's the reason why I make this kind of...
Yeah, I get you, and I completely agree. Like I was saying, that the national courts are also courts of European law and trusted with a European mandate. So, I mean, that's what you're pointing to in this premise, that they need to take this task seriously and do what it takes to give priority to EA law.
Thank you very much. My second question goes actually to, perhaps it's a problem, perhaps not, homogeneity within the EFTA pillar with respect to judicial protection. As you perhaps know, in Liechtenstein, in a way, there's what I claim a strict obligation for a national judge to refer to the EFTA court if he is confronted with an EA question and he is not sure about the impact. And we do have the president and the deputy president, vice president of the Liechtenstein Constitutional Court here. Perhaps I could invite the president of the Liechtenstein Court just roughly to, in a way, sum up what is the Liechtenstein Constitutional Court view about the obligation for a Liechtenstein national judge. Thank you.
Thank you. Well, our position is that if there are real doubts that the judge has, then there is actually an obligation to submit the case to the EFTA court. So we go considerably far in this respect, but it's a standing case law now.
Thank you very much. That concludes for me that then within the EA-EFTA states, Article 34 is applied actually differently. On the one hand, a strict obligation, but not within at least Norway, as you have pointed out. And therefore, my question is, judicial protection within the pillar, different concept. Does that work? Thank you.
I mean, that's the main question. Do these differences, structural and constitutional differences between EU law and EA law, particularly then in the EFTA pillar of the agreement, does this imply a different level in judicial protection? And I cannot see any compelling arguments as to why that should be the case. And difference in the judicial dialogue, to me, that's unconvincing. So even though the relationship between the Norwegian courts and then the EFTA court is more partner-like than in the EU, I cannot see why that matters from the perspective of effective judicial protection, because that's still an obligation which binds the member states. And also, I mean, regardless of an obligation to refer cases to the EFTA court, they do that in practice. So I struggle to see why this key difference entails a difference in the level of judicial protection.
Thank you very much. Now I would like to open for the audience. I understood that, yes, please, from President Kalbamba. Thank you.
Thank you very much. Well, first of all, I want to thank the speaker for such a stimulating presentation, which really went, to the beef. You have asked the question whether Article 47 of the Charter could be of relevance in the EEA law context. I may just point to a judgment which was rendered a couple of years ago, in which I was the judge rapporteur. That is E1014 De Vecchi. In this case, the court had to answer the question of whether the right to freedom to conduct a business, which is laid down in Article 16 of the Charter, would be relevant in an EEA law context. And the court handled this a little bit in a diplomatic way. In paragraph 63 and 64, it said, it's obvious that this freedom is at the basis of the EEA agreement anyway. So we can leave open the question of whether it derives from the Charter or is inherent in the EEA agreement. But a lot of observers have then said, well, they didn't dare to spell it out because it was their first case, but it's quite clear what they meant. They meant that essentially the Charter is of relevance for the interpretation of the EEA agreement. I may quote here Professor Fredrickson, who will speak after you, who has written that, Dr. Floystad, a Norwegian also, and the former president of the European Court of Human Rights, Mr. Spano, who has also said it's quite obvious what they mean. They didn't dare to spell it out. I may also mention that the former Icelandic judge on the European Court of Human Rights, David Thor Björgvinsson, once said, you know what you do if you are faced with this problem? You quote from the Charter without mentioning it. Thank you.
Thank you very much. Are there any other, please, on the left side, please?
Thanks very much, and thank you very much for that presentation. My name is Hendrik Johnson. I'm with the Icelandic Ministry of Foreign Affairs, and I'm very interested to follow all kinds of questions related to effective judicial protection in the EEA. And one question I'd pose to you in a hypothetical manner, to what extent the EFTA court can go to incorporate a principle of effective judicial protection from the Court of Justice's case law and example. If we were faced with a scenario where a provision of EA law essentially doesn't give effective judicial protection, that is what the provision of EA law states. Obviously, we incorporate EU acts into the EA agreement, but there's a process of incorporation and there's possibility of adaptations, and there's not necessarily a clear hierarchy of norms. So a provision of EU law is put into the EA agreement, it becomes a provision of EA law. So if the EFTA court or another EFTA national court is faced with the dilemma of a provision of the EA agreement clearly giving ineffective judicial protection in an EEA setting, what would you think that that court can do? Or is that the point or the limit of the principle of effective judicial protection?
That's a really good question. And unfortunately, now I don't have the answer to that. And I mean, this is due to the fact that the EFTA court is not able to annul secondary legislation stemming from the EU. So if that case would come up, I'm not sure. Perhaps we'd have to resort to judicial resistance from the national courts, saying that this does not comply with basic fundamental EEA rights. So, but I'm not sure how we should deal with that, but it's a real nut and it should be solved somehow. And I think it also relates to the comment by Baudenbacher pertaining to the relevance of the Charter in an EEA context. And the problem is that the EFTA court needs to work with the legal sources they have, and the Charter is not formally a part of the EEA agreement. So it means that they would have to base the principle of effective judicial protection on EEA principles. So the matter is, how do you fill those principles with content? And in that case, I think it's relevant to refer to the case law of the ECJ, and as I mentioned, also bridge the gap by reference to case law from the Strasbourg court. And also, I mean, it's not quite easy with these three courts, each with their individual mandates, but they all try to seek coherence, which is a virtue.
Thank you. There's in the back. Okay, 2 questions, and then I think we have to go to the second. Oh, 3. Okay, I take 3 questions. The ladies first, please.
Yes, thank you very much. My name is Eleftheria Neframi. I'm professor of EU law at the University of Luxembourg. Thank you for the presentation. I have a question concerning the lack of legal basis in the agreement, that is Article 19 of the Treaty of the European Union, providing for the obligation of the member states to ensure to provide effective remedies in the sense of independent and impartial courts. Because, of course, independence, as you very well explained, is a value both for EFTA states and EU states. And as far as it is a value, we have mutual trust. But in the EU law, since the Portuguese judge's judgment, it is not only a value, but it is also a specific and normative specific obligation for the member states to do in case there is a risk of violating the principle of independence. So my question is, do you think that via the principle of loyal cooperation, we could include the obligation stemming as a member state obligation, as an EFTA state obligation, into the EA? Thank you.
Although I admit this is a complex question, the answer is I think you could that, because the rule of law and the independence and impartiality of the judiciary is at the very basis of mutual trust, and it forms, I mean, one of the basic pillars of the EEA agreement. So if the courts in the EEA EFTA states don't function properly, it would be a problem for mutual recognition. Yeah, so I think you could also, based on the preamble to the EEA agreement, state that the basic values and underlying values of the EEA agreement reflects that of the EU, and it's at the very foundation that you need to have impartial and effective courts upholding the rights stemming from this agreement.
Thank you. Now I invite Steph Barrique, college member of the EFTA Surveillance Authority. Thank you.
Thank you very much, and thank you for your excellent presentation, making a really strong case for a level playing field in effective judicial protection. I had actually, following up on this earlier point, and also a bit inspired by the discussion this morning about fundamental rights, I had wondered in a similar vein, shouldn't this effective judicial protection, if it is really a level playing field, also extend so far that our citizens and businesses should be protected against possible breaches of human rights that you find inside a provision of secondary EA law. Of course, there is no right to annul. But what would prevent, let's say, the EFTA court faced with the same question that the ECJ has faced now with Anti-Money Laundering Directive 5 or Test Achats? Let's say the occasion for it to come up just pops up first at the EFTA court. What would prevent the EFTA court, as part of its interpretation, not of annulment, but there's a conflict. There's a provision of secondary law that's, let's assume, clearly, evidently, maybe brutally breaches human rights. What prevents the court from saying, well, fundamental freedoms are an essential part of EA law. I have to interpret these conflicting provisions, and the preponderance clearly goes to the freedoms. And in this instance, we're not applying this particular provision.
I agree with you. That's exactly what I think the EFTA court should do. I mean, they would use the room they have for interpretation and say that we cannot interpret this provision literally because that would infringe fundamental rights. And then just land at an interpretation which complies with basic fundamental rights, and then hope for the ECJs to pick up the ball and do something with the validity of this secondary provision. So I fail to see that they have any other option that would clearly express their stance on the matter, but then with the limited options available, they would have to construe this as a matter of interpretation rather than validity.
Thank you. Now I would give Vice President Lars B. Larsen, in a way, the possibility to address his question. But before doing that, I would like to take the opportunity. Actually, I just learned over lunchtime when I talked to him that it looks like that his days here in Luxembourg come slowly to an end, and I would take the opportunity to thank you very much for all your very kind support of the EFTA court during the last years with the open kind of discussion, exchange of views. So thank you very much from my side for all this support from your side. Thank you.
Thank you. Thank you all. As I speak in this almost semi-personal capacity, but maybe not until for a few days more. I think 47 as an article, I think there were a lot of very good points in the presentation, but for me, the 47, it's surely there. So it's as an easy choice. We had to take it into account at my court. But you can imagine what would happen if we took it out of the game at the EU side. Would it mean that there would no longer be this kind of rule? I mean, the whole charter is based on giving EU rights which are at least at the level of what flows from the European Convention on Human Rights, plus also adding, perhaps in some areas, an additional protection, plus it's a kind of a codification of what seems to be close to other common constitutional tradition than just signing up to the European Convention, or not just signing up, but also to implementing it and ratifying it. So basically, I think the advice that Carl got belatedly was perhaps not, it's an easy way out, but why jump the fence where it's higher? I think it was actually a good piece of advice. You can do what you think is right, following your common traditions or being inspired abroad. I guess you are not forbidden, like we are not forbidden to be inspired by other traditions, unlike what Scalia was arguing in the US Supreme Court. But I think it's not totally black and white.
I completely agree with you. I mean, keeping in mind that the principle of effective judicial protection was there in EU law from the very beginning. And it's a vast amount of case law stemming from the before 2009. So my only point is that when this principle required the status of primary law, it seemed to have led to an evolution in the court's case law. Since it now had a firm legal basis to develop its case law, you could see that it became more assertive. But we don't know what would have happened if the principle hadn't acquired the status of primary law. It might have happened anyway. So but the difference between a general principle and the Charter right should not be overstated.
Thank you very much. Also, again, very special thanks to you, Hel and Hilde, and also for all the ones participating now in this discussion. I see that we have, in a way, used up some more time of the next panel, so next panel will have to be a little bit faster. For this, I will get now the support of two professors, and now we have a little change here upstairs, please, Albert and Monitor. Thank you. For the second panel, here now we will be addressed by two, what I very mean that, eminent EA legal scholars, Professor Holbert Hochland Fredriksen of the University of Bergen and Professor Gunnar Thor Pettersen of the University of Reykjavik for their 10 cases that shaped EA law. Professor Fredriksen is co-director of Sentinel, the Center on the Europeanization of Norwegian Law, which was founded last year at the University of Bergen, and co-authored a report commissioned by the Norwegian government, Norway and the EEA, Development and Experiences, presented to the Norwegian Foreign Minister Espen Barth Eide in April of this year, the one report where my fellow judge, colleague Michael Reitzen mentioned this morning. Gunnar Thor has been the director of the EFTA Surveillance Authority's Internal Market Affairs Directorate, an ad hoc judge at the Icelandic Court of Appeal, and currently serves as an ad hoc judge of this court. The EFTA court has 6 ad hoc judges, and I see a few of them. Special again, welcome also from my side that you embark to come and join this conference. Thank you very much. These ad hoc judges, just to explain that, 2 are nominated in respect of each country who sit when the main judge is conflicted or otherwise unable to do so. Gunnar Thor joined the bench last year in case E523, the criminal proceedings against LDL, what they call our COVID case. And at the dinner the night before the hearing, we discussed what, in our views, had been the court's most important cases, its pearl. It was quite challenging, and many views were expressed and angles taken. So you shouldn't be surprised that we put that on today's agenda to get now a final judgment on this. So without further ado, I gave now the 2 of them the floor. Please. Thank you.
All right, many thanks for the invitation to come here and talk about the cases that have shaped EEA law. It's quite a task we've been given, and we have duly noted the high expectations from President Reinson expressed this morning with some concern. In its now 30 years, the EFTA Court has decided more than 350 cases. with only Iceland, Liechtenstein and Norway in the EFTA pillar for 29 out of those 30 years. This is quite impressive. Equally impressive, almost half of the cases were brought by national courts. In the last decade, the Norwegian Supreme Court alone has sent 12 cases to the EFTA court, whereas different Liechtenstein courts together have sent 29 cases the last 10 years, surely the highest number per capita of any of the EEA member states. In our discussions to select 10 cases that have shaped EEA law, this importance of the national courts has become very clear to us. Almost all of the cases on the list which we are to present stem from national courts. Had it not been for the jurisdiction of the EFTA court to reply to questions put by national courts, the court's ability to shape EEA law would have been very different indeed. Whether that would have led the EFTA Surveillance Authority to bring more and bigger cases, we will never know. But it is striking, in our opinion, that the cases that have shaped EEA law, so few of them are brought by ESA. In the following, we will present what we consider the 10 most important cases. Several of them is a given, others perhaps less so. We have discussed back and forth, but we are still friends, I think.
Still.
Anyway, just like the EFTA court, we will try to keep our deliberations secret. Let's only say that we fully acknowledge that some in the audience might object and find that their favorite case is lacking. The discussion so far earlier today, the cases mentioned, suggest that some will be disappointed, but feel free to take this up in the Q&A session afterwards. We will proceed in chronological order.
True. The first case on our list was given. It's Restamark. It is the EFTA court's first case, indeed, and was decided in December 1994. Just a few weeks before Austria, Finland and Sweden switched from the EFTA pillar to the EU pillar of the EEA, and the Austrian, Finnish and Swedish judges had to leave the EFTA court. It is of fundamental importance for several reasons. That the first case to reach the court was about free movement of alcoholic beverages was no coincidence. The EEA compatibility of the state monopolies on the import and sale of alcohol in the Nordic EEA-EFTA states was hotly debated during the negotiations of the agreement. In Finland, Norway and Sweden, the monopolies were challenged within days of the agreement's entry into force on 1st of January 1994. That Restamark was the first of the alcohol cases to reach the EFTA court is due to the fact that the import rejection question was referred already at the first stage by the Appeals Committee of the Finnish Board of Customs. Whether the committee could be considered to be a court or a tribunal permitted to refer questions to the EFTA court was rather questionable, as it was closely linked to the Central Customs Administration. However, the court held the request to be admissible. In this way, the court, in its very first case, paved the way for the many requests that it, through the years, have received from various appeals boards that might not have been accepted as courts or tribunals by the ECJ. Certainly not after Banco de Santander's judgment of 2020. When the EFTA court upheld its liberal approach in Scanteam in the year 2020, it convincingly noted that the interpretation of the notion of court or tribunal under EEA law must pay due regard to the legal traditions of the EFTA states, including the important role played by administrative appeal boards, and it did so by referring back to Restamark. The main reason for the importance of Restamark is nevertheless the substance of the case and the fact that the court interpreted the provisions of the main agreement on free movement of goods, fully in line with ECJ case law, including Dasonville and Cassis. In this way, in a politically very sensitive case, the EFTA Court demonstrated clearly that its interpretation of the EEA agreement would be guided by the objective of homogeneity between EEA and community law. Tellingly, no mention was made of ECJ's critical assessment of the viability of the homogeneity objective in Opinion 1/91. But as a result of Restamark, the import monopolies were abolished in the Nordic EFTA states. The fact that the logos of the monopolies, which we have included on the slides, is still very much familiar, at least to some of us, is to another court and another case, namely the ECJ's approval of the Swedish retail monopoly in Franzén, which was then followed up by the EFTA Court in a later case concerning the Norwegian retail monopoly. In passing, it might be added that the arguments for a more state-friendly interpretation of the EEA law in Restamark was presented by two future judges of the Court of Justice, Niilo Jeskinen and Pernilla Lind. But they were, of course, only doing their jobs as representatives for their respective governments.
So the importance of Restamark is perhaps best demonstrated by what is arguably the most important of all EEA cases decided on the other side of Avenue Kennedy, the Court of First Instance's judgment in Opel, Austria. From the morning session, we note with satisfaction that both President Reinsson and President Lennart seem to agree with us on this. Since the case has already been mentioned, we will not go into details, but it concerned customs duty on gearboxes manufactured in Austria at a time when Austria was still in the EFTA pillar. What is really interesting with this case is that the Commission and the Council and the Commission argued against homogeneity. And if that argument had succeeded, we would not be standing here celebrating 30 years of the EEA. Fortunately, the Court of First Instance was not convinced by the arguments against homogeneity. It explained at length why the EEA agreement is not an ordinary free trade agreement. And importantly, as a nod of approval to the EFTA Court, the CFI noted Restamark. At a time when references to other international courts' decisions were very few and far between indeed. This is one of the first ones where an EU court refers to jurisdiction, case law from another court. In essence, the EFTA Court had demonstrated through Restamark that it would take homogeneity very seriously, and the Court of First Instance made clear that so would it. Again, as mentioned earlier today, Cohen-Lennart was a member of that panel. But it should also be mentioned that so was the already mentioned Pernilla Lind, who argued Restamark for the Swedish government, now Court of First Instance, and now very much in favor of homogeneity. The reasoning in Opel Austria was so convincing that the Council and Commission saw no merit in any appeal to the Court of Justice.
Well, the second case on our list is also a given, I'm afraid, Sveinbjörnsdóttir, where the court established state liability as an unwritten principle of EEA law. With an interpretation of the object and purpose of the EEA agreement that the editors of the Common Market Law Review characterized as fairly daring, the EFTA Court succeeded in settling the thorny issue of the effect of EEA law within the national legal orders of the dualist EFTA states through a fine-tuned compromise. The EU law principle of direct effect is not part of EEA law, but this is compensated for by an unwritten principle of state liability. For the dualist EFTA states, Sveinbjörnsdóttir was a bitter pill. The EFTA Court was criticized of judicial lawmaking and of acting ultra vires, much like the criticism directed at the Court of Justice judgment in Frankowitz from certain EU member states. It is also worth noting that the European Commission somewhat surprisingly supported Iceland and Norway, but ESA, besides Sveinbjörnsdóttir herself, of course, was the only participant to the case that held that the principle of state liability was to be part of EEA law. The EFTA court didn't accept that the EEA agreement was so different in nature, aim and content from the EC Treaty that the principle of state liability could not be part of it. Rather, the court proclaimed the agreement to be an international treaty sui generis, which contains a legal order of its own, and then deduced from its object and purpose an unwritten principle to compensate for losses caused by deficient implementation of a directive, much like the court had, in fact, of justice reasoned in the classics like Van Gent and Loos and Frankowitz. The Norwegian government sought a rematch in Karlsson a few years later, interestingly enough, without the support of the Icelandic government, despite the case being Icelandic. The EFTA court stood its ground, thus demonstrating its independence from the EFTA states and its commitment to secure judicial protection of EEA-based rights. Notwithstanding the fact that also other cases on our list have shaped EEA law, Sveinbjörnsdóttir remains the jewel in the EFTA court's crown. And as held by Karl Baudenbacher, long time and, let me add, very influential president of the EFTA court, who was also the judge rapporteur in Sveinbjörnsdóttir, in his own words, without the recognition of state liability, the EEA agreement and the EFTA court would never have taken off.
Again, one of the reasons why the EFTA court's fairly daring approach in Sveinbjörnsdóttir proved to be successful was the endorsement offered across Avenue Kennedy. This time by the Court of Justice itself in Rechtberger, only a few months later. The case concerned Austria's liability for deficient implementation of a directive and included a period in time when Austria belonged to the EFTA pillar. The Court of Justice held that it lacked jurisdiction to rule on the EEA part of the case, no surprise, but proceeded to inform the referring court of Sveinbjörnsdóttir in a way that must be regarded as an endorsement of the EFTA court's finding of principles governing the liability of an EEA state for deficient implementation. This endorsement certainly did not go unnoticed by the EFTA courts, which included a reference to it in Karlsson. And it is to be assumed that the support from the Court of Justice also played a role in the subsequent, somewhat reluctant acceptance of Sveinbjörnsdóttir by the governments of the EFTA states. It ought to be mentioned that one of the judges participating in Rechtberger was the first president of the EFTA court, Leif Sevon, who was then one of the judges deciding Restamark. Small community of judges cooperating in different roles.
The first Liechtenstein case on our list is Rainford Towning. It concerned requirements on managing directors of legal persons with business approval in Liechtenstein to be residents of the Principality. The EFTA court made it clear that this was an indirectly discriminatory restriction that violated Article 31 of the EEA agreement. The reasons for the inclusion of the case on our list lies in fact elsewhere, namely in the understanding of the principle of homogeneity. The Liechtenstein government had argued that the case law of the Court of Justice on residence requirements relating to the freedom of establishment was not to be transferred to the EEA due to the fundamental differences between the EU and the EEA. The EFTA court rejected this. It referred to Restamark and then the preamble of the EEA agreement and held that when parallel provisions of the EU and EEA law are to be interpreted, homogeneity should prevail, unless specific circumstances justify another solution. I would like to call this presumption of homogeneity, or the presumption or the principle of homogeneity with presumption. But the homogeneity principle was not called principle in this case. That came later in the Norwegian waterfalls case. In fact, another significant case that did not make it to our list.
This presumption of homogeneity has later been confirmed by the EFTA Court on numerous occasions. One well-known example mentioned earlier today is L'Oréal, where the EFTA Court reversed the stand it had previously taken on the extortion of trademark rights in order to align its interpretation with the one favored by the Court of Justice. In this case, the EFTA Court considered whether the differences between the EEA agreement and the EC treaty with regard to free trade relations with third countries constituted compelling grounds for divergent interpretation. It concluded that it did not. Importantly, this strong presumption of homogeneity has been taken up also across Avenue Kennedy. In numerous cases, the Court of Justice has demonstrated that its starting point is that EU and EEA law provisions relating to free movement is to be interpreted in the same way, so that the internal market can be extended to include the EFTA state. The cornerstone is the 2003 judgment in Ospelt, from which a long line of cases leads up to the finding in IN, or Ruska Federacja, as it has been referred to today, of this special relationship between the European Union, its member state, and the EFTA state. The key is that homogeneity is the default position, and it takes a lot to deviate from it. For the daily functioning of the EEA agreement, this presumption is crucial. Without it, the agreement would never work.
Or perhaps a question for the audience then to come with the answer later. Do you know of any other legal orders that operate on the basis of this principle? But thank God for Ásgeirsson. Even if the origins of court was the substantive core of the Ásgeirsson case, and the case the first and the only time the court was called to interpret Protocol 4 of the EEA agreement, it is best known for being the foundational case on the role of fundamental rights in EEA law. It was one of the plaintiffs that maintained that reference of the case to the EFTA court prolonged the duration of the proceedings and thereby infringed Article 6 of the European Convention of Human Rights. The EFTA court seized the opportunity to state that provisions of the EEA agreement, as well as the procedural provisions of the Surveillance and Court Agreement, are to be interpreted in light of fundamental rights. And as to which fundamental rights the court held, the provisions of the European Convention of Human Rights and the judgments of the European Court of Human Rights are important sources for determining the scope of these rights, much like the ECJ had in fact also done. Even if the Convention and the judgment of the Strasbourg Court are not the only source of fundamental rights that form part of EEA law, they remain of paramount importance. Already in TV 1000, the EFTA Court had cited the Handyside case when discussing the Member States' margin of appreciation. This cross-fertilization is perhaps not surprising, given that one of the judges in the TV 1000 case was Thor Vilhjálmsson, who had earlier been a judge in Strasbourg and as such participated in the Handyside ruling. In Ásgeirsson, the EFTA Court cited Paphitis, in which the Strasbourg Court had clarified that a delay caused by a reference of a case to the Court of Justice for a preliminary ruling was not to be taken into consideration. The EFTA Court saw no reason why a delay caused by a reference to it should be treated differently, noting that such referrals contribute to the proper functioning of the EEA agreement to the benefit of individuals and economic operators. The most recent reference to the case law from Strasbourg is, as has been mentioned this morning, found in the Norwegian Air Shuttle case, where the EFTA Court referenced the progressive ruling from Strasbourg in Klima Seniorinen. And if I'm not mistaken, the EFTA Court was the first court, at least in Luxembourg, to cite that ruling, even if, of course, this is not a competition. The fundamental rights jurisdiction of the EFTA Court has evolved since this ruling in Ásgeirsson, with a clear statement in Holship on fundamental rights as unwritten principles of EEA law as the high point. Whether that case also made it onto our list, you will have to wait and see.
This rather Strasbourg-centered approach established in Ásgeirsson has worked well in many years and in many cases. But it might also pose a challenge in cases where Strasbourg and the Court of Justice in Luxembourg might arguably not be fully in sync. And it leaves open the question of how to proceed in cases where a party before the EFTA Court relies on fundamental rights found in the EU Charter, as highlighted earlier today. The fact that Ásgeirsson didn't solve all questions concerning fundamental rights in the EEA cannot, however, in our opinion, undermine its place on the top 10 list. In our view, the fact that the EFTA Court has taken a step-by-step approach to fundamental rights merits praise. It's a good way to proceed. But the step taken in Ásgeirsson was the first and a particularly important one.
Well, then we have the ISAFE case, or the ISAFE saga, as I prefer to call it. And as any saga, ISAFE is a dramatic story where the cast of characters involves the essential ingredient of a saga, Vikings. In this case, Icelandic financial services Vikings, who raided the kingdom of Northumbria and beyond, meaning, in fact, the whole of the UK and the Netherlands. The background to the case was the financial crisis of 2008, in which all the major banks in Iceland bailed in a matter of days. 3 of those banks had been very active in collecting deposits through online accounts through their branches in the UK and the Netherlands. When they collapsed, the question arose as to whether the Icelandic Bank Guarantee Scheme would be able to guarantee these foreign account holders their minimum amounts. That turned out to be difficult. The Icelandic government issued statements to the effect that the state would back up Icelandic account holders, but not the foreign ones. To cut a long and a very loaded story short, where Iceland's relations to the EU, their Nordic partners, IMF, government of the Netherlands and the UK were put on test, the issue ended up before the EFTA Court in an infringement case brought by ESA. ESA argued that by not ensuring that ISAFE depositors in the Netherlands and the United Kingdom received their minimum amounts of compensation provided for in the Deposit Guarantee Directive within the time limits laid down in the directive, the Icelandic government was in breach of the obligations resulting from the directive and/or Article 4 of the EEA Agreement on Non-Discrimination. The core issue before the EFTA Court was then, of course, to establish what are the obligations resulting from the directive. In short, the EFTA Court ruled that the directive did not establish obligations of result on the states based on a detailed analysis of the scope and objectives of the directive, at least not in the case of systemic bank collapse. The court took the view that the directive was only aimed at sustaining a small or medium-sized bank collapse. One of the essential elements in the reasoning was the concept moral hazard. As noted by the court, recital 16 of the directive stated that it would not be appropriate to impose a level of protection which might in certain cases have the effect of encouraging the unsound management of credit institutions. The court pointed out that state responsibility for deposit guarantee schemes would immunize the schemes from the costs, which ought to be borne by its members. In this context, the court made a direct quote to Professor of Economics and Nobel Prize winner Joseph E. Stiglitz. I will obviously not be standing here and say that the EFTA Court should not reference professors, but it is probably sensible to put the bar high. This appears to be the EFTA Court's view too, Apart from the reference to Professor Stiglitz, the only example to be found in its case law is the reference to Cambridge law professor Catherine Barnard in the Johnson case. Opinions may differ on the EFTA Court's interpretation of the directive, but it ought to be mentioned that following the financial crisis, the EU legislator found it appropriate to substantially strengthen the Deposit Guarantee Directive and also the overall scheme for banking recovery and resolution in times of crisis. At any rate, the ruling in ISAFE showed that the EFTA Court can provide a forum to settle highly sensitive cross-pillar disputes. The judgment, although not uncontroversial, was accepted by both the Netherlands, the UK and the EU, and as you can imagine, Iceland as well.
Next on our list is case E1514, ESA versus Iceland. I sort of suspect this might be the first surprise on our list. The case number probably doesn't ring any bells, even among eager followers of the court. And it will hardly help if I add that the case was about Iceland's failure to implement 2 regulations on the labeling of the fiber composition of textile products. What is more, Iceland did not even dispute that it had failed to implement those regulations, so the judgment was a foregone conclusion and there was no oral hearing. So why is it still on the list? The reason why we include it on the list, besides the fact that there should be some surprises on a list like this one, but beside that, it's because this was the first opportunity for the EFTA Court to express itself on the effect of regulations in the legal order of the EFTA states after the Court of Justice had suggested direct applicability in all EEA states in the judgments in UK versus Council and in Fondship. The EFTA Court was obviously aware of this and the ensuing debate in the literature. In a very low-key manner, the EFTA Court seized this opportunity in a rather ordinary infringement case to reassure the EFTA states that decisions from the Joint Committee indeed don't have direct effect in national legal orders of the dualist EFTA states. This thorny issue was settled by the EFTA Court through the Sveinbjørnsdóttir compromise that we referred to earlier and confirmed in subsequent cases. And it was upheld in this case. Regardless of one's view on whether the EU law principles of direct effect and primacy ought to be part of EEA law or not, and opinions differ on this. But this decision from the EFTA Court clearly demonstrates to the EFTA states, Iceland and Norway in particular, the value of having their own independent Court of Justice for the EFTA pillar of the EEA. And for this reason, we do think that E1514 justify its place on the list.
The next case has already been alluded to and in fact discussed, but I would say this is the case that keeps on giving, Holship. There are at least 3 reasons why Holship has to be on the list. First, because of the substance. This is Viking Line in the EFTA pillar. And the EFTA Court's ruling holds many similarities with Viking Line of the Court of Justice, in particular as regards the balancing of free movement rights and fundamental rights. That balancing ultimately needs to take place at the national level. But the EFTA Court rather clearly suggested that the boycott could not be justified. Further, the Court, in its penultimate paragraph, sent a message that is sometimes overlooked when the case is being discussed, namely that it flows from Protocol 35 that a contracting party cannot make rights conferred by Article 31 subject to international agreements, and in this case, including a specific ILO agreement. Whatever one thinks of the EFTA Court's approach, the Court again demonstrated its independence from the EFTA states, as the Norwegian government sided fully with the trade union. Secondly, wholeship has to be on the list because it is the case where the court made it absolutely clear that fundamental rights form an integral part of EEA law, and in the words of the court, fundamental rights form part of the unwritten principle of EEA law, and they are applicable in all situations governed by EEA law. Thus, the approach taken first in Ásgeirsson was here taken one substantive step further. Thirdly, wholeship has to be on the list because of its aftermath in the Supreme Court of Norway and as well as in the European Court of Human Rights, as we have heard briefly this morning.
In Oslo, the case was heard by the full Supreme Court. The trade union challenged the EFTA Court's opinion on both the law and the facts. The Supreme Court, as has been referred to earlier today, split 10-7 in favor of wholeship and the EFTA Court, one may say. It ought to be stressed, however, and this is quite important, that the minority of 7 justices, they took care to point out that their disagreement with the EFTA Court was based on the facts of the case and not on the EFTA Court's understanding of EEA law as such. Importantly, the Supreme Court also addressed the challenges facing national courts in cases such as this, where you have EU-EEA free movement rights on one hand, and you have convention fundamental rights and even constitutional fundamental rights on the other side. The Supreme Court stated that although the wording of the conditions for restricting human rights and rights under the EEA agreement differ, the nature of the considerations remain the same. And according to the Supreme Court, the outcome of weighing the freedom of assembly against the freedom of establishment should not depend on the set of rules one uses as the starting point. Still, the Supreme Court added that one cannot rule out that the considerations of the Strasbourg Court in weighing freedom of assembly against free movement might come to differ from those of the Court of Justice and the EFTA Court.
A test to that prophecy followed in the very same case, as it indeed continued to the European Court of Human Rights. Final judgment was handed down in 2021, 7 years after the case started in the local district court. In Strasbourg, it was hardly lost on anyone that the case essentially called for a review of the Court of Justice's ruling in Viking Line. In principle, the Strasbourg Court acknowledged that the Norwegian Supreme Court got it right, given its margin of appreciation, but there was more to the case. And here we will limit ourselves to only 2 comments, given the discussion already had this morning. First, does the EFTA pillar of the EEA benefit from the Bosphorus presumption of convention conformity? The Strasbourg Court had answered that in the negative in concurrenten, as we have heard, but in wholeship this question was reopened. In concurrenten, the lack of an EEA parallel to the EU Charter of Fundamental Rights was highlighted, but in wholeship it was acknowledged that the fundamental rights indeed constitute unwritten principle of EEA law, just like they did in the EU prior to the entry into force of the EU Charter. A most welcome recognition of the EFTA Court's fundamental rights case law, which indeed predated the concurrenten case. At the same time, however, the Strasbourg Court pointed to the lack of direct effect and primacy of EEA law in the EFTA pillar, adding also to the pool the advisory character of the EFTA Court's opinion. And despite saying explicitly that the question was to be left for another case, the Strasbourg Court proceeded based on the assumption that the Bosphorus presumption did not apply, despite the fact that none of these alleged deficiencies in the procedural protection of fundamental rights in the EFTA pillar of the EA played any role in the wholeship case. Now, this another case we still remain to see, but I would like to go back to Bosphorus and the reflections on the term equivalence versus the term identical, and the fact that the presumption doesn't require identical protection but equivalent protection. And perhaps we may see for this pillar in the future a mini Bosphorus presumption. Who knows? But it was this sidelining of the Bosphorus presumption which allowed the Strasbourg court in Holship to weigh in on how cases involving EEA free movement rights and convention rights ought to be approached. According to Strasbourg, national courts should not consider the EEA freedom of establishment as a counterbalancing fundamental right to freedom of association. It should only be drawn into the assessment of whether a restriction on a convention right is justified. Non-hierarchical balancing of fundamental rights is only for conflicts of the convention rights. Despite being addressed to the Supreme Court of Norway, it is obvious that this message was also for the EFTA Court, and perhaps first and foremost for the Court of Justice of the European Union. That the Strasbourg Court takes the convention rights as its starting point is hardly surprising, but nevertheless, it's not necessarily very helpful to national courts, which have to satisfy both EU, EEA, and convention obligations. How the Court of Justice will respond remains to be seen, but what is clear, however, is that Holship demonstrates that the EFTA Court too will have a role to play in the attempt to work out the proper balancing of rights and principles.
Next on our list comes not one but 3 cases related to Directive 2004/38 on the free movement rights of Union citizens and their family members. Gunnarsson, Jabbi and Campbell. Some in the audience may argue, or might perhaps consider this a violation of the unwritten principles that apply for any top 10 list.
But we made the rules. So.
Some may even consider this to be an act ultra vires, but we will argue that these principles for top 10 lists have to be interpreted in a dynamic way in light of the specific EEA context of today's presentation. In essence, all these 3 cases concern the same question, whether Article 7 of this directive can be invoked against the home state, so that the home state cannot place obstacles in the way of one of its own citizens wishing to take up residence in another EEA state. Gunnarsson was about Icelandic tax rules, whereas Jabbi and Campbell were about the right for Norwegian citizens to return to Norway with partners from third countries. In these cases, both the Icelandic and the Norwegian government highlighted that the Court of Justice has rejected that EU citizens can invoke Article 7 against their home states, ONB and subsequent case law. At the same time, however, the Court of Justice has concluded that Article 7 applies by analogy in these settings based on Article 21 of the TFEU. So in essence, the EFTA Court had to decide in these cases on whether to follow the Court of Justice's interpretation of the directive or to advocate for a more expansive interpretation of that provision in order to achieve the same outcome in the cases as would have been the situation under EU law. The key to that answer lies in the understanding of homogeneity. What is it really about? The EFTA Court opted for a result-oriented approach. And later it stood its ground in Gunnarsson, and later it stood its ground in both Jabbi and Campbell. In the face of what can only be characterized as fierce criticism from the Norwegian government in particular. At the same time, however, the EFTA Court adjusted and, in our opinion, improved the legal reasoning, first in Jabbi and then again in Campbell, apparently taking into account some of the criticism voiced in the legal literature. We dare suggest that this is an example of fruitful cooperation between academia and an EFTA Court that deserves quite some credit for being open to such exchanges. After Campbell, the essence of the court's approach appeared to be that it is not only possible to interpret Article 7 to entail rights to be invoked against the home state, but also that this is actually the solution that the Court of Justice itself would have opted for if called on to interpret the directive in a situation where it could not fall back on Article 21 of the TFEU. Interestingly, the Norwegian government tried to get the Court of Justice to weigh in on this matter in the IN Ruska Federacja case, essentially asking the Grand Chamber of the Court of Justice to overrule Jabi. The Court of Justice, however, refused to be drawn into the debate. Instead, it decided this case based on Article 36 of the EEA agreement. The case has already been referred to, so we will not go into any details on that. But the important thing is the Court of Justice was clearly aware of this, it was pleaded before it, and it decided to stay out of the debate. The EFTA Court's approach in Gunnarsson came up again in Nordic Info quite recently, but again the Court of Justice refrained from any comments. This time because the EEA dimension of the case was clearly hypothetical, but the Advocate General discussed the EEA dimension of the case and offered his full support, as stated on the slide.
Another, I would say, rather obvious candidate for our list is the NAV case, which, as you can see from the pictures, was decided at the time when the court proceedings happened online. It feels like a long time ago now. In this case, the EFTA Court played an important role in the attempts to right the wrongs after the so-called NAV scandal that shook the Norwegian legal community to its core in the autumn of 2019. For reasons that have never been fully explained, the Norwegian Labour and Welfare Administration, NAV, considered EEA-based exportability of sickness benefits in cash to be limited to cases where the recipient transferred the residence to another EEA state, thus excluding all shorter stays abroad. The recipients of these benefits were met with often ruinous reimbursement claims in cases where the authorities revealed that they had travelled to other EEA states without permission. Several cases resulted in criminal convictions for social security fraud. In an intriguing twist, the Supreme Court was implicated in the scandal as it had passed final judgment in one of these cases. When this case was reopened, the Supreme Court of Norway immediately decided to send a long list of detailed questions to the EFTA Court. The EFTA Court replied after only 10 months with a detailed advisory opinion in which it concluded that the stay requirement violates Article 7 and 21 of the Social Security Regulation, and also for cases predating the implementation of that regulation into the EEA Agreement, Article 36 on free movement of services. All the details are covered in the great contribution yet to be introduced further, the anniversary publication of the EFTA Court written by Halvard and his colleague Professor Christian Franklin, so I will not go further into that here. It will have to suffice for the present purposes to highlight that the Grand Chamber of the Supreme Court endorsed the EFTA Court's finding in full, despite the fact that the EFTA Court had essentially de facto done the whole proportionality assessment itself. It thus seems justified to claim, as President Hrinsson indeed has, that the NAV case demonstrates the close partnership that now exists between the EFTA Court and the Supreme Court.
And then we come to the last case on our list. This is number 10. It's the RS case, also mentioned earlier today, referred to the court by Liechtenstein's Verwaltungsgerichtshof and decided last summer. So it's the most recent case on our list. It's a tax case, but that's not the reason why we have it on our list. Indeed, the Liechtenstein Constitutional Court had in this case already concluded that the tax rules in question were discriminatory. However, the Constitutional Court had suspended the annulment of the national legislation for 1 year for reasons of legal certainty. so that the Liechtenstein Tax Act could be brought into conformity with EEA law. This suspension affected RS and caused the administrative court to turn to the EFTA court. The EFTA court, having first confirmed that the tax rules in question clearly violated EEA law, proceeded to state that it is only in exceptional cases that national courts may temporarily maintain the effects of a national rule that is contrary to EEA law. Remarkably, the EFTA court, without making this very explicit, built on Court of Justice case law, in which the Court of Justice temporarily limits the effects of its own judgments, and not ECJ case law on national courts' ability to suspend annulment of national legislation adopted in disregard of EU law obligations. In this way, the EFTA court avoided having to address the fact that the latter case law from the Court of Justice entails an obligation to refer the matter to the Court of Justice for a preliminary ruling. The EFTA court proceeded to hold that in all other cases, national courts are obliged to let implemented EEA rules prevail, Protocol 35, and even if not stated explicitly in this case, it follows from the facts of the case that this is so even if a higher national court has suggested otherwise. One might be excused for thinking that the EFTA court has studied the Court of Justice judgment in Simmental from the 1970s and tried to get as close to it as possible within the EEA framework. That impression is not reduced by the subsequent reference to the RS case in the very recent case E1023, where the court had held that a national rule whereby a court is bound on points of law by the rulings of a superior court cannot prevent that court from requesting an advisory opinion from the EFTA court. This is, in my view, a rather bold interpretation of Article 34 of the Surveillance and Court Agreement, essentially aligning it to the famous Rheinmühlen judgment of the European Court of Justice. It remains to be seen how this is received by the highest courts of the EFTA states. But in this way, RS is a reminder that even 30 years on, the applicability in the EFTA pillar of Court of Justice classics from the 60s and the 70s concerning the obligations on national courts to apply EU law continues to create headlines. It is also telling that the EFTA court in RS included a reference all the way back to Restermark. In a homage to Restermark court and the surprising long lines of EEA law, it's also appropriate for that reason to include it on our list.
Having now fulfilled to the best of our ability the assignment we were giving to look back on 30 years of case law, we would like to end with a view to the future. Time is almost up, so we will have to be very brief and thus leave any ifs and buts aside. But the increasing complexity of EU and EEA law, the related specialization of EU and EEA lawyers, both in the EU judiciary and at the national level, and the increasing EEA relevance of other agreements mentioned here today, such as Schengen, all suggest that the EFTA Court ought to be strengthened and its jurisdiction broadened to preserve its ability to guarantee a dynamic and homogeneous EEA also in the future. The court itself has very recently submitted to the Norwegian government its own proposal for such a reform as a part of the public consultation on the 2024 report on the Norwegian EEA.
And since Gunnar Thor is an ad hoc of the EFTA court and as such perhaps not entirely neutral on this matter, I shall get the last word here. These proposals need to be taken up by the EFTA states.
Then I shall get the last word on another reform matter close to my heart, not addressed by the EFTA Court in that recent letter. That is the status of the EU Charter of Fundamental Rights in the context of EEA law. The fact that the Charter has yet to be acknowledged by the EFTA states creates difficulties for the EFTA Court and its strive for homogeneity in cases involving fundamental rights not covered by the European Convention. And it sends an unfortunate signal to the EU side. It ought to be remedied by the EFTA states, acknowledging the Charter as a relevant source of fundamental rights in a Europe based on peace, democracy and human rights, as stated in the very first paragraph of the preamble to the EEA agreement. Thank you for your attention.
Thank you both for a very inspiring and lively presentation. And I saw no fighting about microphones. Good if the organizers get 2 microphones on there. So, have a look to the, we don't have too much time, but nevertheless, I would, in a way, by the fact that we have the privilege to have 4 former judges of the EFTA Court with us, and by having in mind that they were once sitting for many years here, probably on these different cases, I would then, in a way, ask them perhaps if they, in a way, something is missing out, one specific case, or which they would like, in a way, to have included. And before giving the floor to the former President Baudenbacher, just a little anecdote. Judge Heikki Kaminen, who is now judge at the General Court, he was, I think, with us this morning. He told me once a little thing what happened on the 27th April 94 when the first case arrived at that time in Geneva, because they were prepared for that. So he was there as a legal secretary, so he, in a way, informed me, we were prepared to receive the first case. So as soon as there was the announcement done, our first case is here, they opened the champagne bottles. And I can assure you that's not anymore a tradition with the EFTA Court. But worthwhile to remind at that time, in a way, being there waiting for the first case, and of course, good, it was about alcohol. So perhaps now I give the floor to former President Karl Baudenbacher, and then I invite then the others very shortly by having, so what is missing? Thank you.
Oh, thank you. Well, I wouldn't say something is missing. Actually, I wanted to say something tonight at the dinner. I will have to change the subject of my dinner speech. But let me say that I found the choice convincing. I mean, you can always, discuss whether one or another case is missing or so, but Restamark, very important. The fact that they didn't throw out the case had also to do with the circumstance. It was the first case. It was the only case of the 5-member court, the first, in its original composition, and so they didn't want to lose a beautiful case. Sveinbjörnsdottir, not much. I could add how much of this has formulated at the University of Texas, where I was at the time. I was commuting between Europe and Texas. Asgeir Sohn taught me how fish is processed on an Icelandic ship. I'm the only continental citizen who knows that. Take off the head, the skin, and salt them and fillet them and so on. Whole ship, yeah. I think whole ship was probably the most important one. What I would have added here clearly would have been the case on the EFTA Surveillance Authority looking into the fining of firms which have violated competition law, but that's a matter of discretion. And then Gunnarsson, Jabi, Campbell, I think it is Per Christiansen who deserves all the credit for these courageous cases. Thank you very much.
Thank you. Now I would like to invite Henrik Bull. Thank you.
Thank you, and
I also think I agree with the list. I noticed I don't think there were any judgments from the time I was on the EFTA court on the list. But of course, courts do not decide themselves which cases that come before them. Perhaps I would also like to emphasize Holdship, because I happen to be the judge rapporteur on the Supreme Court for that case. And as was said, it's really a case that keeps on giving. And the problem that we were faced with was indeed, as was said, that as a national court, you are sort of caught in the middle between international courts that both or all of them, of course, take as the point of the departure their own legal system. The cases really ended up in a very interesting case of European judicial dialogue on many levels. And I think also it's meant quite a lot for EEA law really taking on in the Norwegian legal community. It really brought home, I think, to many lawyers in Norway who really hadn't thought of EEA law as something that really concerned them, that EEA law can really crop up and be important in cases where really nobody thought it would mean much. And so, because of Holdship and then even more, of course, the NAV case, I think the Norwegian judiciary has become a lot more diligent and careful in the way it thinks about EEA law perhaps being relevant in cases where their initial gut reaction would be that this has nothing to do with EEA law, or if it has, it must be okay. Thank you.
Thank you. Now I invite Torger Olesen.
I just want to say, like Karl Bautenbacher, that the list created by Haugland and Gunnar Þór Pétursson is very convincing. Thank you.
Thank you. Last but not least, please, Per.
Well, I thought this was a very interesting and entertaining, not least, presentation. But I think this was a good selection too, and I really don't have anything to add to it. So again, thank you very much for a very nice presentation. I hope you will publish it. I suppose you will.
We'll see. Before now, we would be really sharp on time, but perhaps nevertheless, I would allow 2 questions from the audience, if there are. Yes, in the back, I see one hand. Please. Please push again the button, I think.
Sorry about that. Thank you, Judge Hammerman. I have a question about the rule of law. Many have spoken of that principle today, the importance of the principle and the shared, and that is a shared value and principle across the EU and the EEA states. I would like to ask Professor Halvard and Professor Gunnar if, to which extent this principle is binding up the European courts in general and the EFTA court particularly. An essential aspect of this principle is that our public authorities and maybe and presumably also our courts are bound and operates within the competences trusted to them in legal instruments like constitutions and treaties. How do this comply with broad elaboration of rights and obligations based on, to say it rather in a rather diplomatical way, a fictional fundamental principle retrieved to in absence of legal instrument and resulting in in many of the landmark cases you have told us about. And while on the courts retrieved to this to achieve homogeneity and mutual recognitions of other courts.
That was a difficult one when we're all waiting for the coffee break. But I would say that it all boils down to homogeneity. And I would say that homogeneity is so strongly expressed in the EEA agreement that it justifies what one may call dynamic interpretation, if you like. I would say, I think a colleague of mine in Oslo, Tarjei Bekkedal, has written somewhere that it's more political to go for non-homogeneity than to go for homogeneity. And I think he's onto something there. And is it a rule of law problem? Sorry, Herdis, but I don't agree.
Yes, this is really a challenging question. And as was discussed here by Hilde earlier, and also in the discussions afterwards, does it really matter if the EFTA legal order has exactly the same provisions to arrive to a homogeneous decision? And I would say no, it's not necessarily so that you would need to have exactly the same set of rules. And I'm not going to go into this sort of whole rule of law, case law from the Court of Justice, and how that was sort of the case law, including Article 47 and Article 19 and Article 2, all of which are not part of the EEA. But I would first find it problematic when rule of law was not part of the EEA legal order.
Thank you very much. Now I have the very last intervention by the President, please. And then we go for the coffee.
Thank you very much. I thank you for your excellent list of 10 judgments. They're all very interesting. But it is always difficult to choose between your children. And I thought Carl would mention one of his favorites, that is, of course, the Kellogg's case, where the EFTA court went first to use the precautionary principle for in the case of human health. And I think that is was a great step. Thank you.
Thank you. By that, I thank the two for their, as I think we all agree, and I would like to again applaud to them. And please be back 3:45. Thank you. Enjoy the coffee.
Ladies and gentlemen, please take your seats. Hello, ladies and gentlemen.
Ladies and gentlemen, would you please take a seat? We are just about to start.
Your Excellencies, ladies and gentlemen, dear friends of the Court, we have now come to the final part of this anniversary conference. It falls to myself and Jonathan Tomkin of the Legal Service of the European Commission to present the anniversary publication, the EFTA Court Developing the EEA Over 3 Decades. We, of course, are cognizant of the fact that we have drawn the short straw of being the last presenters, so we will try to be relatively brief. So, I would like to start out by thanking all the authors for taking the time and the effort to contribute, making the book a reality and hopefully a success. I'm very happy to note that many of them, not only the speakers, have been with us here today to celebrate. I will briefly describe the book and its origin, and after that, Jonathan will go further into certain details and explore the themes underlying the book. First question is perhaps, why did the Court decide to publish an anniversary book? The answer is actually quite simple: to maintain a proud tradition. The Court has now published a book on the 10th, the 20th, and if it doesn't fall, the 30th anniversary. So, who knows, maybe in 10 years' time there will be a new volume, 40 years of the EFTA Court, with a chapter on its newfound jurisdiction in the area of Schengen. Who knows? Each volume is a reflection of the state of the Court at the time of its publication. In the first volume, we see the Court having found its feet after what one might term as a shaky start with defection from the EFTA pillar to the EU. This decade saw the Court hand down its foundational judgments, such as Sveinbjörnsdóttir on state liability and Rainford-Towning on homogeneity. These judgments, of course, are fresh in your mind following the excellent presentation by Professors Fredriksson and Peterson. And I would actually argue, if we had asked them to compile a top 3 list of EFTA Court judgments, they should have included both those judgments on the top 3 list. Maybe they will do that at some other occasion. Then we turn to the second volume in 2014. That volume reflects the growing number of cases coming to the Court, and that second decade saw several important judgments. In particular, it was the high watermark of infringement cases brought by the EFTA Surveillance Authority. This resulted in the Court adjudicating in well-known cases, such as the Norwegian waterfalls case, referred to in the earlier presentation, the gaming machines, and last but not least, the iSave case on deposits and the liability of the state in the event of a systemic crisis. In Posten Norge, the Court engaged for the first time in a judicial review of finding decisions in competition law, laying down its understanding of the scope of judicial review to ensure its compatibility with the right to a fair trial. I would argue that case is perhaps, at least perhaps, worthy of making it to the top 10, but as we've seen, views differ on that issue. There were also other notable developments in fundamental rights jurisprudence of the Court. And I would just encourage you to look at these old volumes, and then you will see that these issues I have briefly mentioned are very prominently featured. Now the court has reached the age of 30. Thus, one can say it has left its first youth behind. This means that the court is a more mature and established jurisdiction. As an example of that, one can refer to that the court has, in the last 10 years, received the same number of requests for an advisory opinion as in the 2 previous decades. There are, however, some issues that most certainly do not change. I note that the former President Karl Baudenbacher has unfortunately left us, but in his foreword to the 20th anniversary book, he underlined the importance of homogeneity and relations with the Supreme Courts of the EFTA states. These issues are equally essential for the Court today, and I would say will continue to be so for as long as the EEA agreement will remain in force. If we then turn to the present anniversary book and how it is divided and what are its sections, we start with a section called the Judicial Architecture of the EEA, Past, Present and Future. Then there's the EFTA Court and the Supreme Courts of the EFTA states. Then we come to the substance in the section titled Interpretation and Application of Internal Market Law. There is, of course, a section on EEA and fundamental rights. And finally, there's a section called The Development and Future of European Integration. If I allow myself to start with the final section, it is a contribution by Professor Joseph Weiler and his assistant Andreas Müller, offering, as Professor Weiler is in the habit of doing, thought-provoking views on EU law. Its inclusion in this volume highlights what has been referred to by several contributors today, that the EEA and the EFTA states are, although not at the heart of European integration, a valuable part thereof. As Gunnar Thor noted, they share with the EU and its member states a commitment to peace, democracy and human rights. And as was highlighted on a number of occasions by President Lennartz this morning, judgments such as the very recent Alcaster and more prominently Ruska Federacja are here of crucial importance. Turning to the first section of the book, which is titled Judicial Architecture of the EEA, Past, Present and Future, we find chapters on Opinion 191, which is understandable because without 191 there would not have been an EFTA court. Just to briefly recall, if you've forgotten what was said this morning, that the Court of Justice found that the envisaged EEA court was incompatible with community law as it undermined its autonomy. And in this anniversary book, we are fortunate to have 3 articles exploring this from different angles. The first one is by President Lennartz and his colleague Stanislas Adam, and you will know all about that from this morning. The second one is by Judge Niilo Jaskinen, who has also been mentioned in his capacity as agent for the Finnish government in Restamark. But before he was an agent, then he worked in the Finnish Ministry of Justice, and he was part of the Finnish negotiating team negotiating the EEA. And he shares the personal experience of that in his article titled The Rise and Fall of the EEA Court. And I would in particular like to draw your attention to a section which is rather poetically named Le Naufrage du Fol Espoir. It describes the events of 1991 and how the negotiating teams come to realize that most probably the ECJ will reject the original EEA agreement, and then that does indeed happen, and how they need to improvise and find a solution. I would say that this article is a pleasure to read, and I suspect it was also a pleasure to write because Judge Jaskinen really goes down memory lane in this article. The opinion 191, of course, is not only about the rejection of the EEA agreement, it is of major constitutional importance for the EU legal order. And the President of the General Court, Mark van der Woude, has a contribution titled Opinion 191 Revisited. In that contribution, he examines the opinion and the subsequent case law that built up and followed this opinion. And as the name of his article perhaps gives away, he poses the question whether now with differentiated integration on the horizon, that might not call for a new approach regarding dispute settlement mechanism in treaties concluded by the EU. I find that his conclusion is very appropriate for our uncertain time, as he says, in the current unstable geopolitical context, the European states have an interest in focusing on solutions rather than problems, which I think is very well said. After 30 years of existence, it is time to reflect on the need for a change in the structure and operations of the court, as also referred to on the last slide of the previous presentation. And there are topics on this issue in the book, notably by Judge Bernd Hammerman and Professor Graham Butler. The latter even offers a blueprint of the changes he believes are necessary to the court's governing instruments. Then we turn to the second section, the EFTA Court and the Supreme Court of the EFTA states, and a crucial issue for the EFTA Court. This relationship is the subject of contributions by the President of the Norwegian Supreme Court, Toril Marioi, and her colleague Henrik Bull, as we have found out, a former judge at the EFTA Court, the President of the Icelandic Supreme Court, Benedikt Boasson, and Þorgeir Örlygsson, another former EFTA Court judge. And completing this trio of articles is a contribution by Hilmar Högh, President of the Liechtenstein Constitutional Court. I would like to make 2 points as regards these articles. It is very interesting that the Icelandic and the Norwegian contribution, they reveal the very similar manner in which both Supreme Courts have accorded the advisory opinion of the EFTA Court persuasive force. And in his conclusions, President Högh states that the Liechtenstein Constitutional Court has recognized the primacy of EEA law, including the case law of the EFTA Court, to the greatest extent possible. For those of us who tend to look at the EEA agreement with Nordic dualist glasses, and I can plead guilty to that myself, I highly commend this article for a fresh view on some familiar issues. Befittingly, the book does not neglect the substance of EEA law, internal market law, and that is the third section, interpretation and application of internal market law. There we find various articles on public procurement, state aid, energy, intellectual property, principle of proportionality, the NAV saga, and more. And all those articles are really worth reading and give a good insight into the wide variety of issues regulated under the EEA agreement. I would like to mention specifically the article by Maris Cremona in this section, in which she revisits her rather pessimistic assessment of 30 years ago, when she wrote a well-known article in the European Law Review about the Byzantine complexities of the EEA, and she predicted its swift demise. She recognizes that her predictions were not on point. Then, to conclude, we come to the fourth section on fundamental rights. And there, of course, both Arfinn Borgsen and Hilde Ellingsen have given you a flavor of their articles with their excellent speeches earlier today. And finally, I would like to mention an article named The Right to be Heard before referring to the EFTA Court and after receiving the Court's opinion. There are two reasons why I would like to mention this article and highlight it. The first being that the topic is very interesting and it gives an insight into the reflections of a national judge and the obligations incumbent on him or her when making a reference and receiving it from the EFTA Court. Second is that the author is Wilhelm Ungerang. He is a judge at the Princely Court of Appeal in Liechtenstein. And many of you might not know it, but Judge Ungerang is the EFTA Court's best client. He has, if I'm not wrong, made 21 requests for an advisory opinion today. And I do hope there are many more to come. With this, I have completed this short overview of the book, and I will give the floor to Jonathan to take you through some of it in more detail. Thank you very much.
Presidents, distinguished judges, excellencies, ladies and gentlemen. I'd like to start by thanking the organizers for the kind invitation to participate in today's event. It truly is an honor and a pleasure to be able to introduce this impressive book today. As I plan to express a couple of personal views in the next 15 minutes, I should state at the outset that they are offered to you in a personal capacity. I had the fortune of reading this book over the summer, so the book has been accompanying me in the Mediterranean and the Atlantic, and it's really wonderful to actually meet the characters, the faces, the authors in person at this event. It feels like a family get-together, and I'd just like to thank them for such an interesting read over the summer. As is apparent from Oliver's introduction, this is a volume that offers rich pickings. It's a team of distinguished authors have produced a series of contributions that does many things. It doesn't simply inform, they analyze, they reflect, they make proposals for the future. And the result is a volume that is extremely comprehensive and wide-ranging, both in terms of its scope and in terms of its depth. One element that I thought to highlight is that while each author focuses on a specific theme that they've chosen, what you see when you read the different collections together is that they interact with each other, they engage with each other. So what happens is that you feel as a reader, we're invited into the room for a high-level dialogue between absolute experts in the field. And this approach has a lot of advantages. It allows important themes to be approached from different perspectives, be it from supranational institutions, from the court, from national judiciary, as well as from academics and practitioners. So you really see that the different contributions speak to one each other, and I'll give a couple of examples in a moment. Another element which struck me when reading the book is that when the separate contributions are taken together, they actually bring together or read like a story. There's a narrative. And I would propose to briefly highlight a few of the plot points that emerge along the way. So essentially, the book opens with the meeting of the parents and a birth. And as President Leenaerts and Professor Adams' contribution notes, anniversaries are a time when we take out the photo album. We learn how two opinions of the Court of Justice were decisive in shaping the very DNA of the EEA legal order. The opinions clarified that the extension of the application of EU norms to an EEA setting had to be done in a way that would preserve the autonomy of the Union legal order. And with that, the EFTA Court was born. Now, in Shakespeare and in Shakespearean drama, you might know that the specific character traits of the hero are typically decisive of the plot. And this could also be said to apply to the EFTA Court. As Professor Weiler and Andreas Müller's paper suggests, even institutions can be subject to a certain genetic determinism. The contributions of President van der Woude and Judge Jaskinen explore the conditions that would shape the institutional blueprint of the EEA legal order. And this blueprint didn't just define how the court would function, it would characterize the nature and the type of the institutional challenges that the court was destined to face. And in this context, we learned that a key challenge of the EFTA Court has been to ensure homogeneity, to ensure that relevant norms of union law are applied uniformly and correctly in the EEA context, and that is notwithstanding the specificities and the differences of the EEA legal order. So far in the story, we've been introduced to the parents, the hero, the challenge has been set, and now we're introduced to the skeptics. And as Olafur explained, Professor Cremona revisits her earlier writings from 1994, in which she expressed doubts about whether the court would be up to the challenge. Professor Cremona recalls that by comparison to the Union legal order, the EA was conceived to be more economic in nature and less political, both as regards its nature and as regards its ambitions. Given the different context, it couldn't be taken for granted that identically worded provisions would be interpreted in the same way. The challenge was exacerbated by the fact that in the early years, the extent of the authority and the influence of the EA institutions was not certain. While Protocol 35 gave precedence to EA law, its wording seemed to limit the possibility for direct effect. And this afternoon we were speaking and listening a little bit about this issue and this impact in fundamental rights. Equally, it was pointed out that initially there were doubts about the authority and status of advisory opinions. Another potential obstacle to homogeneity was how to pronounce the word. Oh, that's a joke. It was the absence of corresponding provisions of primary law, and of course the absence of an express framework for regulating fundamental rights. In a series of contributions, the authors examined the different ways in which these challenges have been faced and how they've been overcome. Now, certain authors approach this question and the challenge from a sectoral approach. So Professor Ronstad, Mathisen, Haraldsdottir, for example, examined the development of EA law focusing on specific sectors. We look at intellectual property rights, state aid law, and energy. Other contributions focus on methodology. Peterson and Einarsson consider proportionality and the delimitation of scope. So at this point, I think I mentioned that this book was my summer read, and you might notice, therefore, that it has actually some of the features of a John Grisham novel. Its main protagonists are lawyers. There is a challenge to overcome. There are skeptics who think it's not possible, and there's plenty of court action. Now, without wanting to spoil the plot for you, I think it's fair to say that the outcome has been remarkably positive. And if we take the various contributions together, it may be possible to identify two key drivers of this success. The first key factor is what we heard now through the listing of the top 10 judgments, is the approach of the EFTA court itself. We learn how the court has interpreted the principles of loyalty and homogeneity in a way that could fill many gaps. A number of the contributions highlighted the Jabi and Campbell case and how the court was pragmatic in ensuring effects results-based homogeneity. This meant that even if the legal framework was not identical, it was possible through divergent interpretation of secondary law to ensure homogeneity in result. And for my part, I think all three judgments certainly deserve to be in the top 10. Furthermore, the absence of direct effect was mitigated with an expansive interpretation of the obligation to interpret in conformity with the EA law. And we heard also just now earlier about the importance of the RS judgment and its approach to integrating a concept of supremacy. Equally, we learned that the EFTA court was very fast to transpose ECJ case law on state liability, to recognize that fundamental rights form part of the general principles of unwritten principles of EA law. And the means by which fundamental rights are protected in the EA legal order was subject to thought-provoking contributions by Bortsen, Ellingsen, which you heard today, Ungerang, and Floistad. So that's the first key element of first key driver of success, it would appear, was the work of the EFTA court and its approach to its case law. Perhaps the second point to identify was the fact that overcoming the challenges was in fact a team effort. It was a partnership between the EFTA court and the national courts of the EFTA states that were applying EA law. President Hoch's contribution gives us insight into how Liechtenstein, aided by its monistic national order, has accepted the primacy of the EA law, including the case law of the EFTA court, even if at the same time that acceptance was subject to a constitutional reserve over core constitutional principles. We also learn from Entner, Koch, and Schobel how Liechtenstein has ensured effective engagement through the establishment of a dedicated EA coordination unit that I got to meet last night. As regards Norway, we learn from President Oy and Judge Bull about the partner-like relationship between the EFTA and Norwegian legal orders. We learned that after a period of calm, there is a steadily increasing awareness of EA law. Since 2015, there has been a considerable increase in the number of referrals from the Norwegian Supreme Court. And if we look at the case law, which is surveyed by Professor Mestad, it's clear that the advisory opinions of the EFTA Court are to be followed as a general rule in the Norwegian legal order. Deviation can only be envisaged for weighty and compelling reasons. It's acknowledged that the EFTA Court has specific expertise and a special function with respect to ensuring the uniform interpretation of EEA law. In Iceland, the approach is comparable to Norway, as Olafur had just pointed out. We learn from Presidents Bogason and Erliksson how in successive important cases, the advisory opinions of the EFTA Court were recognized and implemented by the Icelandic courts. The case law recognizes here, too, that there's an obligation, what we learned this morning, to take account of advisory opinions, and again, deviation only possible in exceptional circumstances. One point that I noted in relation to Iceland, and that the contributors suggest that the possibility to ensure this kind of compatibility was not necessarily because of, but in spite of national law, which they suggested were diluting the precedents of EEA law. And it's noted that in their contribution, the authors suggest that this would be a matter for the legislators to fix. So an element that becomes clear throughout the volume is that the EA legal order and the Union legal order share a number of features and challenges in common. And I would just briefly point out 3 or 4 that came to mind when reading the book. The first one is that, like the Union legal order, the strength and effectiveness of the judicial system is dependent on the willingness of the national legal communities and the national courts to engage with EA law. And that means to identify and raise questions of EE law, and then to ensure that the answers which are given after questions are referred are integrated into subsequent rulings. But we learned that just as in the Union legal order, EA points haven't always been raised or detected, or sometimes they were detected late. And one thing I just thought to share, speaking with EA agents in various cases, because I have the pleasure to plead regularly before the court, I sometimes heard of stories about the difficulty that agents had in having points of EA law recognized, of being recognized that there's a question to be asked. Yet, such perseverance has led to very important cases being raised and clarified. Professor Ungerang's contribution highlights the value in ensuring that parties can agree to the question submitted. And there I just thought to share one experience, at least in one member state, maybe the one I know best, where normally the judges actually ask the parties to draft the questions. And of course, then the judge writes the order and of course will have the final say. But the advantage of that approach, the advantage of the parties actually writing the questions, is that there's a greater chance of the outcome to be relevant and useful. As in the Union legal order, sometimes there are divergences emerge on certain issues between the EA and the national legal orders. And at the same time, what's clear from the book is that there's a mutual resolve to ensure active engagement. And as Fredrickson and Franklin's contribution illustrates, on the one hand, Supreme Courts have been more ready to make references and to engage in dialogue. On the other hand, the EFTA Court has shown itself open to clarification, amplification, particularly where there may be new considerations that could lead to a nuancing of an answer. Professor Sanchez-Grels notes that the willingness of the court to engage speaks volumes of the EFTA Court's institutional commitment to sincere cooperation and judicial dialogue. Another point of comparison between the EFTA and Union courts is the form of the rulings and the reasoning of the court. And here, Judge Ryertson's contribution surveys, quite exhaustively in fact, the nature of the EFTA court reasoning and notes how the EFTA court, like the Union Court, engages in what it refers to as principled reasoning, that is, reasoning that operates at a level above the specific facts of an individual case. Now, sometimes such principles are general when they're very, very broad, and other times they're a little bit more concrete. And the level of magnification will often depend on the need and the context. And remember, and I said at the beginning, one of the things that struck me about the book was that different sections were interacting each other. Well, if one then turns also to President Oy's and Judge Bull's contribution, they also pick up this theme of the magnification of reasoning. And they say that higher level principled reasoning would in general be more appropriate or functionally appropriate, given the nature and purpose of the advisory opinion. At the same time, an opinion that is too high level and too principled could also be unhelpful where it appears that a case-specific reply could usefully be given. So, coming from a common law jurisdiction, I just thought to offer the following brief reaction. Perhaps it's possible to approach the issue of magnification from a different perspective. One of the elements of common law judgments is that the reasoning of the courts tends to be highly case-specific. A great deal of the judgments are structured around the arguments of the individual parties to a case. But then, once they analyze the questions, the reasoning often refers to elements of principle. Now, maybe one could say that regardless of common law or civil law, a court ruling or opinion doesn't have to choose between principled reasoning and case-specific reasoning. Indeed, it's possible that a judgment or opinion need neither be one magnification nor another, but can be multifocal. In the end, it's arguable that judgments generally go, and need to go, as far as possible to provide an answer that is relevant to the litigating parties, even if that involves reformulating or narrowing the questions asked. And while there may be a legitimate desire to avoid asking too fact-specific questions, the other extreme raises issue of feasibility and utility. What I mean by that is that if the EFTA court is asked questions which are so broad, like what is X, and that sometimes happen, it's not necessarily feasible to provide a reply that is useful. And also, well, basically to write an essay is a long process, and if you have to be too general, then you won't get to the essence of the problem. And perhaps we're now at a stage in EA law where the difficulties in the cases are not so much at the level of principles, but how they're applied in specific facts, in the specifics of a case. Now, in terms of the structure of judgments, whereas the reasoning of the common law, as I was saying before, is a little bit bottom-up, the reasoning of the union courts, of the EFTA court, of the ECJ, tends to be top-down. There may be advantages, and there are also cultural differences, but personally, one of the advantages of the top-down approach is that basically the text introduces the forest before it goes down to look at the trees. And it means that it's easier for judgments to be pedagogical. The elements of the judgment that are horizontal and principle-based are readily signposted, they're readily flagged. And that makes it more easily useful if you're doing research, and more easily understandable where the level of principles lie. And that helps because, of course, the cases don't just resolve an individual case, but because they're used to resolve different cases. Lastly, another point in common between the EU and EE legal order are the question of core values, which we touched on briefly. As President Reissen notes in his foreword, EEA states share with the Union and its member states a commitment to peace, democracy, human rights, and the rule of law. Indeed, the case law of the Court of Justice has underlined the special relationship between the EEA states and the Union. And as we also heard this morning, this relationship is based not just on the proximity through the EEA agreement, but also by other spheres of cooperation. And refer here, for example, to the Schengen area and the tapestry of rules that underpin the functioning of that area. As Secretary General Blanchet noted, the COVID pandemic has shone a spotlight both on the extent of free movement rights and the extent to which we can take them for granted. At the same time, Blanchet has highlighted the jurisdiction gap. And in fact, it's notable that the COVID pandemic offers a very specific example of a jurisdiction gap. It has given rise in certain legal orders to legal questions and important judgments concerning the Schengen acquis, but there's no mechanism for ensuring a uniform approach among the EEA states. So I would echo the comments that what we learned about mutual trust earlier is that mutual trust is not just about trust in the norms, but it's also trust in the procedures that relate to the interpretation and the application of the norms. So insofar as the norms are there, but there isn't a mechanism for ensuring an EEA coherent interpretation of Schengen rules, there's a gap. And that gap then goes to the heart of mutual trust. So it would seem that that gap would merit reconsideration. So I would just echo what was said just before. As mentioned, the introduction doesn't just inform and analyze it, but indeed it looks to the future. And I would just draw your attention again to the thought-provoking contributions by Judge Hammerman, Professor Butler, Professor Weiler, and Andreas Müller. And as we saw before, these proposals cover a whole range of different topics. The appointment process, the number of judges, the possibility of having advocates generals, panels, the scrutiny of appointments. So very wide-ranging, really interesting thoughts on the way ahead. So it hasn't been possible and not possible to do justice to this book in the available time. However, I hope that we've given you a little preview, some sense of the immense depth and range that this book covers. The contributions that make up this volume represent a substantial and engaging tribute to the EFTA Court and the Court's case law, which is equally substantial and engaging, and now is spanning over 3 decades. So I just want to wish happy birthday and warmest congratulations again to all the contributors for this incredible achievement. Thank you for your attention.
Ladies and gentlemen, now we have come to the last item on our agenda today. The Court is delighted and honoured that State Secretary Maria Vartersian from Norway has accepted to close this anniversary conference. State Secretary Vartersian is a member of the Labour Party, and prior to taking up her current post, she held various offices, amongst others with focus on climate change and energy. As State Secretary, she is responsible for European affairs, which of course includes the EU and the EEA, amongst other things. As she is the only politician in this room today, I am certain that she will offer us something different from what has been served up so far. One word of organisation. Following her address, President Hreinsson will say a few words of farewell, but State Secretary, welcome. The floor is yours. Thank you.
Thank you. Thank you so much. Wow, it's truly great to see such a large turnout at the end of a conference. That's great, and I will try my best to offer a different perspective. But first of all, allow me to say, Mr. President, Excellencies, ladies, gentlemen, present and past judges of the EFTA Court, it's truly an honor to be here. To celebrate the 30th anniversary of the EFTA Court. And I would like to say thank you so much to the previous speakers for your insightful, very detailed, and very interesting interventions. Now, as mentioned, I am the State Secretary, Deputy Foreign Minister of Norway, and I have the most exciting portfolios. With responsibility for the High North, the Arctic, green transition, and most importantly, Europe, and Norway's relation to the EU, and of course the EEA agreement as the important centerpiece of it all. Now, I have had the pleasure this year of attending several conferences marking the 30-year anniversary of the EEA agreement, and it has been great. But allow me to say that none of the other events I have attended have been so academic as this one. And I have learned a lot. My advisor, Hans, has also learned a lot. He has taken very detailed notes, and he will be writing a very detailed report on this conference. It's true. It's true. And I have to say that I'm truly honored, and it is very inspiring to be in a room with so much competence and knowledge on our most important agreement. And yes, the EEA is the most important international agreement that Norway has. Throughout the 30 years we have had it, it has served us well. It has proved to be a sound basis for economic and political cooperation, fostering economic growth, innovation and prosperity to mutual benefit of all parties. I often say and think that, well, Norway would have been a much poorer country in a broad sense if we wouldn't have the EEA agreement. But what makes the EEA agreement truly special is not, well, it's of course the things I mentioned, but it's the fact that in the times we're living in right now, the EEA is the connection point of Norway to the European Value Club. In geopolitically turbulent times that we're living in right now, having this connection is more important than ever, having connections to friends and partners that share our values. Now, we all know that the world is changing. It's quite a dark place right now with a grim geopolitical backdrop, a lot grimmer than 30 years ago when we got the EEA agreement, which was just 4 years after the Berlin Wall fell down or was torn. As you know, democracy back then, it was trending. There was even literature written about it with Francis Fukuyama's End of History. Well, he later wrote other books saying that he was wrong. But there were also music inspired by it. Scorpions, Wind of Change, I'm sure you've heard it. Multilateralism was flourishing. That was the golden age of peace treaties, agreements. And friends, where are we now? Well, it's quite a contrasting situation today. And as the world changes, so does the EU. And Europe, of course. And recently we have received not one, but 2 reports written by previous former Italian prime ministers about the state of the internal market and European competitiveness. The latest report is Mario Draghi's report on competitiveness, really saying that, well, Europe is lagging behind in this increasingly turbulent world with great power rivalry and especially the competition between United States and China, challenging the very core of the multilateral system, which has served countries a medium-sized open economy such as the Norwegian very well. Well, that's under pressure. And the other former Italian Prime Minister, Enrico Letta, released a report in April saying a lot about the state of the internal market. And he called his report much more than a market. And the parallel to this is, of course, that the EEA agreement is much more than a trade agreement. The EEA agreement is the safeguard of common interests, rights, and economy. And I would call it as something as big as an anchor of Norway's cooperation with Europe, built on shared values of peace, democracy, human rights, and rule of law. The very values which are so hardly contested and challenged today, not least by the war, full-scale war, raging in Europe. Just a few weeks ago, Enrico Letta was in Oslo, in Norway, by invitation from the Norwegian Prime Minister, Mr. Jonas Gahr Støre. He visited Norway to contribute to a conference which the Prime Minister himself initiated, and the government of Norway arranged together with the Norwegian Confederation of Trade Unions, who, by the way, are also represented here today, and the NHO, Confederation of Norwegian Enterprises. And the focus of this conference was on the state of the single market, where it is going, focusing on Enrico Letta's report, and also Line Eldring's review of the EEA agreement and what it has meant for Norway in the last 10 years. The Prime Minister Jonas Gahr Støre held a keynote speech underlining the importance of the agreement. So although we are talking a lot about the legal details of it all, it's really right now, it's existential, it's very much about big politics. Now, friends, we know that the challenges we are faced with currently, they go beyond borders. And cooperation with like-minded partners has never been more important. Neither has upholding the very values that the EU is built on, without which the EU would not really exist. Now, by previous speakers, the word trust has been used. And allow me to say that trust in our mutual support and respect for the rule of law, well, it's the very linchpin of our value club. Global pandemic, as has been mentioned, Russia's war of aggression on Ukraine, climate change, and I could have mentioned several other challenges. Well, these crises can only be fought through collective effort. Now, a lot has changed, as I mentioned, since we got the EEA agreement 30 years ago. But despite the fact that a lot has changed, the agreement itself has proved to be both flexible and adaptable and robust. And as the world turns more unpredictable, the agreement represents stability and a solid basis for collective effort. At the same time, the current and ongoing geopolitical changes influence policy development in the EU in various ways, which in part challenges our connection and relationship with the EU through the EEA agreement. Whereas parts of the policy which is being developed as a response to these changes fall under the EEA agreement, larger and larger parts fall either partially or completely on the outside of the scope of the EEA. So what we must do is to adjust to this complicated reality in a holistic and a strategic manner. And this is a high priority of my government. Now, a lot has been said about the importance of the EFTA court, and there are many great examples which are already given, so I will not repeat them, but I would like to focus right now on the importance of the EEA agreement's institutional framework, of which the court forms an integral part. Because it is the foundation of the agreement, and it ensures our commitments are made tangible through common rules applied in a consistent, correct, and a uniform manner. The institutional framework makes the agreement unique, and it is fundamental to the success of the agreement itself. Now, the decision-making structure ensures the continuous update and necessary development of the agreement, as you know, and the enforcement mechanisms secure uniform interpretation and application also on the judicial level. Without the institutional framework, we cannot fully achieve the objective of the EEA itself. So on behalf of the Norwegian government, I would like to convey our gratitude to the EFTA court for your contribution to the functioning and I would say success of the EEA agreement throughout the 30 years we have had it. Thank you so much. Your contribution is crucial for the trust and the legitimacy of the agreement itself. The court is a guarantor for legal certainty and contributes to securing the EEA rights of individuals as well as of businesses. And of course, the court provides important clarification on EEA law also for the governments of the EFTA states. Now, as I have already mentioned, the world is changing and so is Europe as a response to that. And I often think of the EU really as a crisis management mechanism that develops a new set of policies in order to adapt to the world around. And how does that reflect in everything we have spoken about today? Well, it affects the way policies are made, and there is a growing regulatory action now with more intricate legal questions. It's challenging. All of you know that better than anyone. And now, we acknowledge that the court sees an increasing volume of complex cases, and this is also a part of the recommendation in Line Eldring's report. We take that very seriously and consider on how we from the Norwegian side can do more to strengthen the court, considering it now, but it has the highest priority. Because neither the single market nor the EEA agreement can be taken for granted. If we want the EEA agreement to still serve us well, we must do what is necessary to maintain it. And of course, to maintain it, we need to, from the Norwegian side, prioritize to take down the backlog. We're working on that, but we also must supplement the agreement in areas where we see it is of key interest, national interest, but also interest of the EFTA states, and of course, in the interest of the EU and the EFTA states together. This involves having an open discussion also on the institutional framework. Now, I have taken the note of court's response to the Norwegian review on the experiences of the EEA agreement and the recommendations that follow. And I have also listened with great interest to the Secretary General's Blanchet's intervention concerning an extension of the enforcement mechanism of the EFTA pillar earlier today. And like I said, in Norway, we're currently looking into the follow-up of the EEA review, and I can assure you that this will receive the necessary political attention it deserves, because this is big politics in a time where the EEA agreement matters more than ever. And we need the court to deliver quality judgments and to safeguard the values underpinning the agreement for the future. Lastly, I also want to thank everyone here for your work and your engagement and your contribution to the functioning of the EEA every day. Friends, I work with the EEA every day, and the more I work with it, the more I realize how exciting and important it is. So I feel it's unfair that it doesn't get more attention than it does. It deserves a lot more attention, but allow me to say that so do you, all of you. Working with the EEA, knowing about the technicalities, you are part of the machinery keeping the EEA agreement alive. And you deserve all of the credit and attention for that because, well, you're champions of the EEA. You are. And what you do is incredibly important for the continued success of the EEA. So friends, allow me to end by saying that I would like to, from the bottom of my heart, congratulate the EFTA Court on a very successful conference and, of course, the publication. And happy anniversary. Thank you for your attention.
Ladies and gentlemen, dear friends, I would like to thank the State Secretary Barteresian for her excellent speech and for being with us here today to celebrate. We have now reached the end of the road, and I sincerely hope that you have enjoyed the conference. I want to thank everyone who spoke here today, as well as all of you for attending. It was a pleasure to welcome you here in Hemicycle to take part in our celebrations. We plan that next year the court will hold its regular spring conference, and I hope you see you then. Although the conference is now finished, there is still plenty to talk about, and I hope you will stay and enjoy the refreshments on offer. Thank you very much, and I hope you see you soon. Thank you.